Representative Downs, it's nice to see you're on. I'm so sorry for all that trouble before.
No problem. I have no idea what happened.
You sound great. We're loud and clear. Thank you. Whoops. Admit. What's happening to my other co-hosts? You're not admitting people.
Representative Moriarty looks almost invisible. Oh, there he is.
Hi, everybody.
Good morning. Good afternoon, almost.
Yeah, you got a minute left.
Yeah.
Enjoy it.
We'll just be a moment before the rest of the committee members join us, so we'll get started very shortly.
And it looks like AFA won't get to us for quite a while yet.
Oh, is that the case?
Yeah, I've been sort of in and out since 10 this morning, and they're only on their third presentation, and we're toward the end.
Well, when I disappear, that means it's happening.
Well, it's good they're doing a careful job.
Yeah, yeah.
Thorough.
Let's see. Yeah, we're seventh, and I think they're still on their third presenter.
Let's see, I'm gonna turn off my screen and my audio for a moment and see if I can assist any committee members in finding the link or anything. So I'll be right back, everybody.
Okay.
Hey, Sam, how have you been?
I'm good. I'm good. Thank
Good.
you very much.
I'm glad I get a chance to work with you again.
Yes, as well. You as well.
Yeah, yeah. Are you covering both committees?
Yes, I'm co-staffing both of them. We have a new analyst I'm working with on the IDEA committee, and
Oh yeah. Okay. Yep. Yep. Okay. Okay. And did I see that you just became a member of the bar?
yeah, I've been a member of the Massachusetts bar for a good decade, but I hadn't taken the main bar, and I decided to do that this summer, and I did, and was admitted.
God.
So
Congrats.
thank you.
I can't imagine taking a second bar exam 10 years after the first.
I couldn't either.
I had to do that when I moved to Maine, and it was a real struggle.
Wow.
Just
Oh.
to study again.
Oh, sure. Sure. I can't imagine.
I'm jotting down
Neuroplasticity is a
that
thing.
Tom is from away, but that's all right.
It's well known. It's well known, Christopher.
You know that, Chris, anyway. Or Jeff, rather.
So the good news is the power came on 10 minutes ago,
Oh,
so I can come to this meeting. So
Lois, I was just trying to figure out how to connect with you to see what the status was.
yeah, the power came on about 15 minutes ago. So, and I managed to get my computer to be charging again, and I found Soupy's email, and here I am. So I just missed a 10:30 to 11:30 phone meeting because I didn't want to use my phone up in case I didn't have a computer or a phone. At least we have a house that I have a gas fireplace, so which so we weren't freezing, and there was hot water because I have a gas water heater. So there we have it. So I'm alive and well.
Well, it looks like we have a quorum. And so let's start our round of presentations for today. We'll actually begin with committee member introductions, and then we'll move right into the Christian Civic League of Maine everybody will have 15 minutes to do a presentation. And if it seems like your presentation might exceed that time, I'll just gently interrupt and let you know that your time is up. Please do try to leave time for some questions, actually, because that's often helpful for us. And so let's go into just brief committee introductions. And Lois, since we're all amazed that you're here and your power is back on, why don't you start and I'll just go through the list.
Yes, I'm Lois Reckett. I represent District 31, which is the ocean and now powered again end of South Portland.
Steve Moriarty.
Yes, hi, Steve Moriarty from District 45, which is Cumberland, home of the Cumberland Fair, and part of Gray.
Thank you. Representative Sheehan.
Thanks, Madam Chair. I'm Erin Sheehan from House District 12. That is downtown Biddeford.
Thank you. Is Representative Hagan, he is probably still in school. Representative Downs.
Hi, good afternoon. I'm Representative Downs and I represent District 130, which is Bucksport and Orrington. Thank
Great,
you.
thanks. And Representative Libby.
Hi, I'm Representative Laura Libby. I am from Auburn and I represent District 64, which is part of Auburn and all of Minot.
Thank you. Representative Poirier.
Thank you, Madam Chair. Jennifer Poirier. I represent House District 107, which is all of Skowhegan and a small part of Madison.
Thank you. Representative Evangelos.
Good morning, everybody. Welcome. I look forward to hearing from you today. Jeffrey Evangelos, House District 91. I reside in Friendship.
Thank you. Representative Newell.
Thank you, Madam Chair. Good afternoon, everyone. Rena Newell, Passamaquoddy Tribal Representative.
Thank you. And Representative Babbage.
Good morning. Chris Babbage is my name. I represent House District 8 in Kennebunk, where the snow is gently falling. As of last Monday morning, we had 398 COVID cases in this for the year in this municipality. And of course, you know, York, Androscoggin, Cumberland, and Oxford in that order are the per capita leaders in the state, the only ones over the state average.
Thank you, Representative Babbage. I believe that, Representative Harnett.
Thank you, Madam Chair, and good afternoon, everyone. My name is Tom Harnett. I serve as the House Chair and I represent House District 83, which is the town of Farmingdale and the city of Gardner. And I may be disappearing from this meeting for a while at some point to sit in on the Appropriations Committee meeting, but I will be back. Thank you.
Thanks. Senator Keim and Senator Sanborn, I believe, both have scheduling conflicts with this meeting, so they may at some point be able to join us. I'm Senator Ann Carney. I represent Senate District 29, which is South Portland, Cape Elizabeth, and some of Scarborough. And then I would ask our legislative analysts and committee clerks to also just briefly introduce yourselves. Thank you.
Hi, I'm Peggy Reinsch. I'm going to be monitoring the Appropriations Committee. So I actually have two laptops in my office right now. So I'm trying to juggle those. I will be listening, but I'm going to be off camera.
I'm Samuel Seneft, and I am the co-staff legislative analyst.
And I'm Susan Panett, and I'm the committee clerk for the Judiciary Committee.
Thank you all very much. And with that, I think we will dive into our first presentation with Mr. Conley.
Well, actually, I'm substituting for Mr. Conley. I'm Mike McClellan, the Christian Civic League of Maine Policy Director. So I want to thank you, Senator Carney and Representative Harnett and the entire committee for 15 minutes. That feels like forever. Most committees give 2 minutes. So I'm Mike McClellan, Policy Director for Christian Civic League of Maine. I live in Raymond, where it has actually been snowing for about 40 hours. and we're up to about 6 inches. I was a rep. I served the town of Raymond, Casco, in Poland, the seat that Jessica Fay now has, for 6 years. And I served on the education committee all 6 years. And I served every session, I served another committee as well. So I served on 4 different committees, not your committee though. So, but I am here to speak about the Christian Civic League of Maine. And we are an organization that doesn't testify a lot in this committee, but it seems like we're there once or twice every year. So let me tell you about that a little bit. We are a 125-plus-year-old organization. Every state has an organization like ours. Often they're called family policy alliances. In our 125-plus years, which goes back into the 1800s, we were involved in community issues like women's suffrage and prohibition. Currently, we focus on things like life, human sexuality, marriage, parental authority, and religious freedom. So our mission as such is we seek to bring a biblical perspective to public policy. So a couple of notes I want to make really clear. We are not the voice of the evangelical church. The church is very diverse, and there's so many churches, we often don't agree with each other on specific issues. So we clearly are not the voice of the church. Second note, we do inspire to be accurate and an inspirational source to Christians. And as such, we do what we do in hopes that we encourage them to participate in the process, them to come to committees like yours and testify and whatever. So I think it's really important for us to say, as a Christian organization, we have not always done our job well. There have been times we've not done the right thing, and we need to own that and just strive to do better. So some of our beliefs, we believe that God has put each one of you where you are today to serve the people of Maine. He picked you specifically for this job. We believe that government is good, and we say that because the Bible tells us that government is a good thing. We're stereotyped because we're Christian and we're conservative as a conservative Republican organization, but we're not. We're nonpartisan. We are focused on policy, and we're not focused on the R's and the D's. And as an example of that, we've worked with LGBTQ organizations multiple times, even in my 4 years, on issues like adoption. So now we've been asked our mission in the past, and then we've been chastised by the person asking because they say, well, why do you want to inspire? Why do you want to put your Christian beliefs on society? But we believe that all laws are based on morality. And so we advocate for things that we think are biblical, that we think are time-tested ethics. And that's kind of one of our motivations. Our motivation also is not just to change laws, but our motivation is that we believe what we're espousing. When we come to you to speak, it's what we believe. We believe there's a God of the universe who created everything. And we believe that God sees all people the same, whether their color, their gender, what country they were born in, on and on and on. He sees them all as his. So we, again, believe that the things that we espouse are for the benefit of all. So in closing, which I'm sure has not been 15 minutes, we believe in advocating for truth, basically hoping that it will draw more people towards him. And as I said earlier, I did serve 6 years. And so I know the fun aspects of being a legislator, and I know the many aspects that aren't as much fun. And so I just personally know what you've gone through or what you're going through. And I want to thank you at this point for your service, because it's integral to our society, to our state being good. And I'm open to any questions. I'm sure I've got a few minutes left.
Thank you very much, Mr. McClellan. Does any member of the committee have a question? I see, and Representative Reckett has reminded me to ask all committee members, this meeting, let's try using the raise hand function that is part of the reactions menu. And Representative Reckett, you may ask your question. Thank you.
Hi. I guess when you're a former rep, you're still a rep. Is that accurate? I never know what to call people.
I think they say honorable.
Oh, honorable. Okay.
And,
So,
and what I will tell newbies, I had to say this the other day because I was on the insurance committee and I testified the other day. If you are a former rep and you testify at a committee that you served on, you're supposed to bring treats.
right.
And
That part I
couldn't do
knew.
that. But I wasn't on your committee, so unfortunately I don't owe you any treats.
Anyway, my question was about something you said at the beginning of your presentation. You said that your group had been active in women's suffrage and
Yeah, a long time ago.
I forget what the other part of that sentence
And
was.
prohibition.
Prohibition,
Yeah.
which of course women's suffrage was active in prohibition too, but a lot of it.
And
My
life, and
question
life
is-
issues, actually. Yeah.
Yeah, my question is, were you at that time for or against women's suffrage?
Oh, we were promoting women's vote. Yeah, definitely.
Okay.
Yeah. And it's a great question. Since I probably have time, I'll go into it. As you may or may not know, before my time, before I was even in the office, the Christian Civic League went through a tough time where it was a pretty negative experience. I really don't want to go into it. I wasn't there. Carol Connolly, who was our executive director, he wasn't there. He was brought in to fix it, actually. And I came after him. But there was a lot of negativism towards our organization to the point people didn't want to even talk to us. And so we've really tried to turn that around, and hopefully I've espoused somewhat, what our belief system is. We were very involved in community and in the days before, like say the 90s, I guess. And somehow it's flipped to the legislature, and that became the big focus for our organization, working with you folks. We're actively working now to add pieces to our program that are back to community, back to supporting churches that aren't political. And we've done a program with job fairs in churches, which help people actually targeting felons who then hopefully get a church family to belong to and also a job out of it. We also have worked on a program which isn't political, but bringing pastors to Augusta to meet their representative, to meet their senator, not to talk about politics, but just to say we're praying for you, that we know what you're doing is important. We know what you're doing is taking away from your own life, and we just want you to know we're praying for you, just building relationships. So we're looking at some ideas for working with adoption more so, and other things like that. We're known for politics, but we really historically have been in the street organization.
Thank you. It looks like we have one more question from Representative Evangelos. Go ahead.
Hey, Representative.
Hi, how you doing, Representative McClellan?
I'm doing okay. I'm warm and it's pretty snow. How are you, sir?
I'm doing
We
good.
served together for like 6 years, I guess.
Yeah. I just wanted to say that I probably never vote the way you want me to, but you and Mr. Conley are always friendly and polite in the hallways and set a wonderful tone of comedy and bipartisanship. So while I don't generally probably get your approval on my votes, it hasn't stopped you from being civil in the hallway. So thank you for that example. That's all I had.
Very kind of you. And you did actually vote when I was a rep. I had what was it? The lake bill. I had a bill to clean up lakes, and you did support it.
Thank you both. Representative Babbage, I think, and maybe this will be the wrap-up question. Go ahead.
We served together too. He's muted.
I thought it was going to be quick, but I apologize for that. Good to see you, Mike.
You too, sir. Representative.
What I want to say is just I appreciated what you said today, but I wanted to know if you could clarify just a little bit then who it is you represent. Maybe you can help me with like how are you funded as an organization? Sure. Or thanks, I appreciate it.
Sure. I have an office manager. She's actually better than that. That's a terrible title. She does so much. And I was complaining one time about mileage, that I wanted more mileage because I was driving a lot. And she told me about opening letters from little old ladies that donated $2 to our organization. And one day I was opening the mail and I literally opened a letter that had $2 in it from a little old lady. we don't get any government funding, although I think we did get the COVID funding. I think we did, but we don't go for grants. We don't go for that kind of funding. We are totally funded by people that believe in our organization and believe, excuse me, in our mission statement. And so that, we skin of our teeth. We hopefully we're stealth and efficient with our money, but it is tight. So we don't have members. Like I used to run a chamber of commerce where we had members. We don't have members per se. There's not something like that. But again, as I would say, we have people that pay attention, and that includes individuals, and then that includes churches. There are churches that regularly give to us. There are people that regularly give to us. Does that answer your question?
I'm better educated. Thank you.
Oh, great. Thank you very much. And thank you so much, Mr. McClellan, for being here today. We appreciate you spending some time with us.
Yeah, thank you. And God bless you all. And I really mean that. So good luck. And I will see you eventually.
Thank you.
Take care.
And we'd ask you to sign off and join us on the YouTube if you want to continue to be involved.
I will do that. Thank you so much.
Thanks. All right, next we have the Maine Association of Criminal Defense Lawyers, and we have Attorney Walter McGee here. And there he is. Go ahead and welcome.
Thank you very much, Senator Carney, Representative Harnett, and members of the committee. My name is Walt McKee. I chair the legislative committee of the Maine Association of Criminal Defense Lawyers. And I have never served as a representative, although I think I've spent a fair number of hours in your committee and in the Criminal Justice Committee. So sometimes I kind of feel like I'm almost part of it, although I don't get to sit, as you say, around the horseshoe. MACDL, MACDL, as it's commonly referred to, has been around for over 30 years. And we have been an organization, actually just shy of 30 years, that has been comprised of criminal defense lawyers that practice all over the state. We have a very vibrant group of criminal defense lawyers that are committed to representing the rights of the accused. Oftentimes, there's a little bit of confusion in terms of what our role is when we come before you. Our role is really to talk and give you really the other side of the coin when it comes to criminal justice in particular. You won't see us before your committee talking about anything other than criminal justice issues that happen to come before your particular committee. We're not there for defendants per se. We're not speaking on behalf of the so-called criminals, if you will. We're really there to speak about the process. And we do this in a very collaborative way. We have worked with the Maine Prosecutors Association and many of the groups that are going to speak to you in the course of all these presentations to come to agreement about what appropriate criminal justice changes should take place. Now, we don't always agree, and often we're on the other side, but I will tell you that more often than not, we will agree with many of the proposals that are being made. We're not always there in opposition, and we work with other groups to make sure that the decisions that you make are ones that are truly informed. As I said, our members practice all over the state, and I think that when it comes to our group, we really are those that are the most truly committed to a fair and appropriate administration of justice. One important piece that you'll hear from us time and again, and this is something that will be echoed in the Criminal Justice Committee as well, is that we don't really draw broad and specific lines, but we do when it comes to things like mandatory minimum sentences. It's something that our organization has strongly been opposed to since we've been testifying before you all for the past decade or more. And that's because of our view that judges should make those kind of decisions, and that as much as we appreciate the input that the legislature provides in those decisions, that ultimately it's the person on the bench hearing all of the information from both sides when it comes to sentencing so that they can make the appropriate decision without an artificial, if you will, floor mandatory minimum sentence that would apply to each and every case. I mentioned that just in particular because it comes up time and time again before your committee and the Criminal Justice Committee. And it's something that you'll hear us talk about, and I'll repeat many of these same words to you when those bills come before you. That being said, we don't have any other agenda than coming to you and talking to you about what the other side views the particular bill. And I am confident that you all will hear and listen to myself and others that will come before you. Although I chair the legislative committee, there are others on the committee as well who will appear from time to time. It's of course very easy now to do it through Zoom. One of the reasons I was up before you so many times was not because I was uniquely qualified, it's because I can literally see the State House from my office right here. So I was the person with the shortest walk. So I got to come over and see you all. But I've been doing this long enough to know at least a little bit about how the process works. And so I think you'll be seeing me a fair bit this session as well. I don't need the full 15 minutes to talk to you all and introduce myself. I know many of you, nearly all of you on this committee now, but I hope that if anybody has any questions, you'll feel free to reach out to me now or certainly in the future. And I look forward to working with all of you going forward.
Are there, I see quite a few questions. So we'll start with Representative Moriarty and then Representative Babbage and then Representative Breckett.
Madam Chair, with your permission, I have a question for Walt, which arises out of our discussion on Tuesday at the conclusion of our formal agenda, specifically relating to parole. So if I may,
Yes, go ahead.
Walt, this is sort of coming out of left field probably, but can you just tell us roughly what percentage of convictions in Maine include a sentence, a portion of which is suspended and involving a corresponding period of probation?
Don't know. That's a number that the judicial branch may have. Very difficult one to nail down. They certainly know the number of probationers out there, so it's probably a good measure of that. But there's certainly a large number of people out there on probation. It's something that your committee and other committees have dealt with over the years, and to try to manage the number of people who really need to be on probation versus those that were just automatically put on probation as a matter of course. So I don't have a firm number for you, Representative Moriarty. There are a lot. Probation's important, but I think over the years there's been a real effort to try to put people on probation that really need probation and the specific conditions that come along with it, as opposed to just something to be added on to the end of every sentence.
Okay, thanks. And a quick follow-up. What are the current good time provisions for people serving sentences?
So they vary. And so depending on whether this is you have been convicted or not. And so there's a bill, I think it's going to be presented in this session that will increase the amount of good time for those who have, before they've actually been sentenced, to try to reduce the number of people that are actually sitting in jail. Certainly something that's gone back and forth over the years. In the 90s, that changed significantly, where there's good time credits were far more significant back then. They swung back the other direction so that people served more of the actual sentence. Don't have any firm numbers for you. Happy to get them, though. I think it's an important measure. And I think it will really help as you look forward and you're looking at sentences to figure out, well, what's going to happen in terms of the number of people in jail or at the Department of Corrections.
Okay, thanks very much.
Thank you. Representative Babbage? Chris, you're still muted.
Apologize for that time. Good to see you again, Mr. McKee. I know you're not a legislator, but your wife nearly had my job 25 years ago. She would have been the first of her party in 75 years, 5149. Yeah, so I had an ulterior motive. I wanted to keep her in Kennebunk, but that might have delayed her meeting you, so that's all right. What I wanted to ask is, do you and the Maine Association of Criminal Defense Lawyers, do you monitor at all the number of judicial nominations that come from the defense side as opposed to prosecution?
So we don't monitor it. We're well aware of it. I'm fairly well aware of it because I'm on the committee. I think that there has been a push by the governor as of late to balance things out. 60% of the current judicial branch are former prosecutors. And that's not necessarily a bad thing, but I think that there's a view that there should be some more diversity on the bench so that there will be criminal defense lawyers. There will be people from private practice and from a bunch of different places. I think there's a number of reasons why prosecutors might, there may be more prosecutors on the bench than otherwise, separate from any particular political bent. But I do see a change in that. And I think if you see the governor's recent nominations, you'll see a very interesting and impressive group of people coming from private practice. So I think we're going to see the numbers shift in a different direction to give some better professional diversity to the bench.
Thank you.
Thank you. Representative Reckitt and then Representative Harnett.
Am I muted or not muted?
I can hear you.
Okay. Of course, I see you in both committees where I'll see you again this year, and I'm not sure whether this question is more criminal justice focused, except it really is. There is an area where this committee and the other ones, at least philosophically, overlap in terms of adjudication and the law. I assume you're aware there's a move on to decriminalize a whole lot of stuff this year, if we possibly can, or to change it to fines instead of incarceration. Is your group well aware of that, I assume, or?
We are. It's something that we're going to support. We've supported different efforts in different in ways in the past years, but we're certainly going to be in favor of that. Just because of a lot of plain reality, which is most of these people aren't going to jail anyway. But even putting them under the prospect of that is a little bit unfair. A lot of Title 12 offenses, and different people have different views about this. The IF&W offenses are one area very of great interest. Years ago, they switched back to all criminal, many of them from civil, and that certainly had some consequences. But I think that many, certainly our group will support, and many will support the decriminalization of a lot of Title 12 offenses and a whole host of others. So we're definitely have our eyes on that. It's going to be a top priority for us.
Yeah. Thank you.
Thank you very much, Mr. McKee. And I think that and I'm sorry, Representative Harnett, go ahead.
Thank you, Madam Chair. And apparently I need a remedial lesson on raising my hand electronically, which I support completely. Nice to see you again, Mr. McKee. I have a COVID-related question, and it comes from an article that I read about a colleague of yours who is representing a man who's being held in county jail because he's not able to post his bail. And as a result of that, has lost his job, lost his home, because the courts are not able to prosecute his case, to handle his criminal matter. Can you talk briefly, and I know we're short on time, but how the inability of the courts to do arraignments, to do criminal work is having on people that are presumed to be innocent?
Yeah, they're stuck there, and they're stuck there indefinitely. Until trials aren't going to take place until at the earliest June. And I think that's a little bit rosy. So I think for those folks that are in jail, pending trial, they can't bail out, that they're in the worst possible position. Everybody else can kind of wait, but you're sitting in jail, potentially doing more time than you would if you just went ahead and pled guilty. You're in a bad position, and it often forces people to just plead guilty because they want to get out of jail, because it's going to be 5 more months before they get to trial. And any judge would sentence them, if they just pled guilty, to a sentence shorter than they've already served. I think those are real pressures that should not be in place at all, and that there should be a view that bail really should be something that's available, especially now, without trials happening on a more regular basis. We're trying to deal with that judge to judge, and it's going to be difficult to legislate that, but it's a major factor. And I think the most important one is because people are actually in jail as opposed to pending charges and being out on bail.
So is it fair to say that people are in jail simply because they don't have the financial resources to meet the bail?
Well, potentially it's a measure of what the court sets the bail at. So yes, at a certain level, they can't get out because the bail is $5,000. They don't have that. Even $1,000. Sometimes it's $100. I don't think people appreciate enough. Sometimes they just don't have any money at all in the first place. I think there's been an effort to get people out, but I'm confident there's still people there that simply can't afford the bail and can't get out. And their remedy is, well, I'll wait for my trial. Well, good luck. It's going to be this summer.
Thank you. Thank you very much.
Yeah, thank you. Representative Evangelos, do you have the final question?
Thank you, Madam Chair, and I'll be very brief. I just wanted to quickly comment. And hi, Walter. It's great to see you.
Yeah, great to see you too.
And thank you for all the valuable work. The newcomers to our committee are going to come to understand what an asset you are to my state. And I seriously mean that. You've done tremendous work.
Thank you.
I just wanted to chime in. I just read a study by the Robina Institute of Justice, which analyzes sentencing and prison release. And they've ranked Maine very poorly. To answer the question, you have to if you're an absolute angel in prison and never get in trouble, you're able to have up to a 23 to 27% reduction in your sentence. That's about the way the statistics are working right now. But they also said that Maine has the most determinate sentencing in the country, and one, if not the worst, harshest release systems. So we need to do a lot of work in this area. We can't be sentencing people to these inordinate sentences. Rehabilitation and redemption are so important. But I just wanted to I think it was Representative Moriarty asked the question, it was somewhere between 23 and 27% of your sentence can be reduced for good conduct, but everything's got to go perfectly. Thank you.
Thanks for that additional information. And with that, thank you very much, Mr. McKee, for joining us today. And if you would like to continue to listen, can you please hop over to the YouTube channel and so we can save room for other panelists to join?
I will. Thanks again. Appreciate it.
Thank you. Our next panelist is the American Civil Liberties Union. And I think we have several representatives. And let's start with you, Megan Sway.
Thank you, Senator Carney, and hello to members of the committee. There are many new faces. My name is Megan Sway, and I'm Policy Director at the ACLU of Maine. And with me today is my beloved colleague, Michael Kvede. He is Policy Counsel at the ACLU, and he'll be introducing himself in a little bit. I will keep this short since we are in the lunch hour. I just wanted to give those of you who are new a little bit about the ACLU. We are the state affiliate of our national ACLU. So they have policies that they put in place that we follow, but we set our own priorities about where we put our resources and spend our time. The mission of the ACLU is to defend the Constitution and Bill of Rights and to make sure that its promises extend to all people in Maine. And we do that through three primary ways. First, public education. So we do a lot of know your rights trainings. We do social media campaigns. When we were still getting together in person, we would go to conferences or to talks and talk about the Constitution and people's rights under the Constitution. And because we're not here together today, I can't give you our little pocket Constitution, but I will send them in the mail to everyone because that is probably the reason people invite us to the committee to introduce ourselves is the little pocket Constitutions we give out. We also, of course, are litigators, and the ACLU of Maine started in 1968 with a group of volunteer lawyers who took on cases of constitutional significance pro bono. Since that time, we've grown, and now we are a staff of 13 full-time staff members. We have 2 litigators at the ACLU, our litigation director, Emma Bond, and our chief counsel, Zach Hayden. You may see one or both of them before you this session, but generally speaking, they are involved in complex litigation. So they don't get to have the fun that Michael and I get to have by coming before you and talking with you. Some of the cases that we've done over the years have been some of the most consequential civil rights cases in Maine. Some of the ones that come to mind recently are we sued, on behalf of our client, we sued Aroostook County for violating the 8th Amendment, which is the prohibition on cruel and unusual punishment, and for violating the Americans with Disabilities Act for not providing medication-assisted treatment to our client when she was serving her jail sentence. We represented a young high school student in Cape Elizabeth who was exercising her First Amendment rights to discuss some of the sexual assault problems at her school, and she was unfairly punished. So we brought a case on her behalf. And then a few years ago, we sued the city of Portland for violating the First Amendment in its panhandling ordinance. So we have cases that run the gamut. And if you have questions about our cases or our law, you should feel free to reach out to me or Michael. Michael and I are part of the policy team. So we are the two policy members at the ACLU of Maine, and we spend our time mostly in Augusta, but also sometimes in municipalities, testifying on legislation that impacts people's civil rights and civil liberties. And in the Judiciary Committee specifically, in recent years, we have been before you and you all have done some really amazing work that intersects with our priority areas. For example, you all passed unanimously a bill to fund a court notification system so that people who are awaiting their court dates get a text message like you get before you go to the dentist or the doctor. And in other states, this is shown to reduce the failure to appear in court by up to 50%. So this allows law enforcement to spend their time on public safety issues rather than arresting people for forgetting to show up in court. And it prevents unnecessary arrests and just helps people, remind people and keep the court going on a regular basis. We also worked in this committee on a bill that ended the mandatory suspension of driver's licenses for failure to pay fines that were not related to driving, for criminal fines that were not related to driving. And that's an issue that really affects rural Mainers, especially who need cars to get to work and couldn't afford their fines because they couldn't afford to get to work. So those are just two examples of some of the bipartisan work that we've done in this committee in the last several years. And it's just a joy always to come before you all. Before I turn it over to Michael, I will just say, since there are so many new faces, that it's been my experience in the ACLU that we have no absolute friends and no absolute enemies. So for those of you on this committee who generally think of yourselves as agreeing with the ACLU, I can guarantee that there will be a time when we take a position that you cannot stand and you don't understand why. That will happen. And for those of you with whom we usually disagree, I'm sorry because we're always right, but there will be times when we agree and we can work together. And so it's one of the both joys and terrible things about working for the ACLU, that no one always agrees with us or always disagrees. And I invite you all to reach out to me. The one pager has both Michael and my email addresses, and we are always happy to talk to anyone. Michael, I don't know if there's anything I left out or if you want to cover what you expect will be in the committee talking about this session.
Sure. It's a pleasure to see some familiar faces, and welcome to the new faces that have just arrived in the Judiciary Committee. I spent so much time in this committee last session that I almost changed my mailing address, but the pandemic prevented that. I will add to the list that Megan outlined and to the list in your handout that we'll be spending a lot of time talking to you about bail, which we did last session. And that was one of our biggest legislative priorities last session, to reform the bail system, which if any of you wants an in-depth conversation about, you should absolutely feel free to talk to us about. And we'll also be talking to you about sealing criminal records, another topic that I pontificated to you about a lot last session. Representative Talbot Ross convened a committee that I see Andrea Mancuso here. She was on. My former boss, Frank D'Alessandro, who's also in this Zoom but invisible, was also on, and many other stakeholders were on. We achieved consensus over what criminal records should be sealed, when and how. And this committee passed that bill, but the pandemic prevented it from hitting the floor. And so you should expect to see that in the next couple of months. Yeah, those, I don't want to just read to you what's in the handout, and you'll hear more than enough from me over the next few months. So I'll stop there.
Thank you very much. just for those watching, members of the public watching, we have invited all of the presenters to also provide us a one-page handout that gives us a summary of their organization and priorities and contact information, in case you're wondering what we're all referring to. Are there any questions among committee members? I think we have time for 1 or 2 questions. Not seeing any hands. Am I missing anybody? If so, wave vigorously. No? Okay, great.
Smart people, thank you so much. We'll see you again later in the session.
And that brings us to our next presenter. It is the Maine Coalition to End Domestic Violence. And Andrea Mancuso, I believe, is with us already. Welcome, Andrea.
Thank you, Senator Carney. Good afternoon, members of the Judiciary Committee. First, thank you for making this time available for me to come and talk to you about the work of the Maine Coalition to End Domestic Violence and our member programs. Thanks to Sue and Peggy for finding a time that worked, though I do cringe to be following the act that is Megan and Michael and all of the wonderful work they're doing. I'm Andrea Mancuso. I'm the Public Policy Director for the Maine Coalition to End Domestic Violence. I'd love to start by giving you just a brief overview of what the coalition does and what some of our member programs are doing. The coalition was founded in 1977. We really exist to support and represent our membership, which includes the 8 domestic violence resource centers that serve Maine's public health district, as well as the Immigrant Resource Center of Maine, which provides culturally specific services, both independently and in collaboration with the domestic violence resource centers, which we often refer to as the DVRCs. Combined, these regional resource centers provide services to more than 12,000 survivors in Maine in 2020. In your packets, you should have a one-page handout that reflects the state and where all of the local domestic violence resource centers are. On any given day, the advocates in our network of providers serve approximately 500 survivors in Maine. And many of the staff within our membership are also survivors themselves. While people frequently think of domestic violence shelters as the core of our services, the resource center and the resource centers operate 11 emergency shelters throughout Maine. Less than 5% of the people that we serve each year ever come into these shelters. In addition to the shelters and our 24-hour helplines, which I'm hopeful everyone is familiar with, the domestic violence resource centers in Maine provide a broad range of advocacy services. This includes advocates who act as liaisons within child protective services. They provide specialized assistance to families who are engaged in the child welfare system, as well as training and consultation for both the child welfare workers and advocates within their own resource centers. It includes advocates who receive referrals directly from law enforcement and then initiate contact with those survivors. And also, when appropriate, will actually accompany law enforcement to meet with survivors in their homes or wherever they've relocated to. It includes advocates who help survivors navigate a variety of systems and access resources, public assistance programs, including housing assistance, prevention programming and intervention services for youth. Folks are in the schools, working with Job Corps, college, and on university campuses. It also importantly, I think for this committee, includes advocates who assist survivors in navigating our civil justice system. Maine's courts see between 5,000 and 6,000 protection from abuse filings each year, and the advocates from our domestic violence resource centers assist survivors at every stage of this process. They really are indispensable resources for survivors and the variety of professionals that are involved in these cases. In addition, many of the resource centers either employ attorneys directly on staff or contract with members of the private bar to represent survivors in family matters and in complex protection from abuse cases where it really is going to require an attorney. On behalf of the state's domestic violence resource centers, MCEDV or staff from those programs help inform the state's response to survivors at a number of statewide tables. This includes the Maine Commission on Domestic and Sexual Abuse, which I know you heard from earlier in the week. Our work there currently includes leading a broad multidisciplinary subgroup of the Commission on enhancing the state's response around firearms relinquishment when perpetrators become prohibited either as a result of a protection from abuse order or a disqualifying conviction. That really is a 2-year project that we've sort of taken on, and we're about half of the way through that, and are thrilled at the broad range of folks that are really working very collaboratively to make the process more effective under the scope of the current law. We also sit on the Domestic Abuse Homicide Review Panel. Any day now, the biennial report will be issued, and this particular report is going to not only speak to the 2018 and 2019 cases that the panel reviewed, but it will also contain a look back over 20 years of the Homicide Review Panel's work, doing case reviews and recommendations. We sit on the Child Death and Serious Injury Panel, the Maine Child Welfare Advisory Panel, Maine's Justice for Children Task Force. Our executive director, Francine Stark, co-chairs Maine's independent panel to review the use of deadly force by law enforcement. Around elder work, we're on the Council on Elder Abuse Prevention, as well as the Elder Justice Coordinating Partnership. Our executive director sits on the Justice Assistance Council for the state. We're also participatory in the Sex Trafficking and Exploitation Network, as well as on Maine's Continuum of Care Board of Directors. So we bring our perspective to the legislature as you contemplate changes in our statutes and identify areas for further study. One thing that I think is important to leave with you is that while some of the people who commit domestic violence do spend time in jail or in prison, the vast majority of domestic violence offenders live in our communities and are present in the lives of those they've harmed or continue to harm. And so much of our work is around risk assessment, risk management, safety planning, and our systems of public assistance, healthcare, and access to the courts really are critical resources for people coping with abuse and violence. This committee has played an essential role historically in that work over the years, particularly around the evolution of Title 19A, which contains the Protection from Abuse statute and the Family Court Code. In the 130th legislature, we'll be in front of you offering input regarding an array of bills that have been introduced that will intersect with our work. I hope that you will see us as a resource as you sort through those bills. In terms of what we have before you this session, at the sort of informal direction of this committee's chairs in the 129th, we've been part of a team that has reorganized the Protection from Abuse statute. While making no changes to the existing law that governs this process, this collaborative recodification effort will give us a statute that will be more accessible to those who engage with it, has much needed structural changes to enhance understanding in judicial economy. We're also going to be asking you to take a look at considering mandatory training for guardians ad litem, who now receive only an hour and a half of domestic violence training across their 4-day roster training, which really does not reflect the proportion of cases that guardians are asked to work on that involve domestic abuse and violence. We see the family court as where long-term safety and stability of survivors and their children is really attended to, and guardians play a critical role in that. It's quite long overdue for them to have better tools to be able to engage in those cases. Also, at the direction of the 129th legislature, we completed a study on the impact of economic abuse on survivors in our state, confirming that the overwhelming majority of survivors in Maine do experience economic abuse. The 129th legislature responded to that and codified a definition of economic abuse and created some new relief in the PFA statute, as well as a couple of consumer protection provisions. And this committee was a huge part of making that happen. So thank you to the returning members for that. We'll be asking this committee to take an additional step to support divorcing survivors whose long-term financial prospects are diminished as a result of economic abuse perpetrated by their spouse within the context of the marriage. Looking forward to working with all of you, as well as our community partners on these and the vast array of other things that I'm sure you'll hear from us on. Thank you again for having us here today to talk about our work, and I'm happy to take any questions that anybody has.
Thank you very much. That was a very thorough explanation, and thanks for touching on your legislative priorities as well. Do members of the committee have questions? Representative Babbage, go ahead.
This time I'll unmute more. quickly. Good to see you, Ms. Mancuso. I was just looking
Yes,
at
sir.
your board. Can you hear me okay?
Yes.
Yeah. I was just looking at your board of directors, and there are 3 former representatives on there that are some of the most impressive leaders we've ever had in the legislature. So they all could have been governors, I think. And so I commend you for having such great people. I wondered if you could reflect a little more on the 2000. Thank you for those numbers for 2020. I think that's enlightening. But how do they compare to pre-COVID 2019? 2019.
Yeah, thank you for that question. And you do have our annual report, which has a whole bunch of statistics, and I'm happy to get you whatever other information might be helpful. In 2019 and 2018, we served between 13,000 and 14,000 folks. So we're about 1,000 survivors less in 2020, which we're actually kind of thrilled about, because it means we actually got most of the people that would traditionally get to us into our network. At the very start of the pandemic, we sort of had a frozen gasp and were really concerned because the hotlines went silent. But we worked really collaboratively with a vast array of community partners to make sure that word got out that the advocacy centers were still operational, the hotlines were still there, services were still being provided. And it was a very short window. So, I mean, I think where we see the impact is you'll see from our numbers that we actually had more calls into the hotline, and the calls were longer because the barriers and obstacles that folks are experiencing as a result of the pandemic are heightened. Their challenges are greater, and that reflects too on the length of stay for folks that are coming into our shelters. We observed about a 13% longer stay, and we had to pivot to sort of hoteling folks as opposed to bringing them into the bricks and mortar shelters. That is the traditional approach for safety reasons. It's harder for folks to find that permanent stability with everything that's going.
Thank you.
Thank you very much. Your Representative Reckitt.
I just, this is not a comment, is not so much for Andrea as for the other new members of this committee who have no idea that I spent 37 years working in one of these domestic violence resource centers. So I'll tell you up front, I have prejudice generally in this arena. So I tell you that up front, but I'll be truthful and honest, and you can just hope for the best. So anyway, I'm glad to see you again, Andrea, and I look forward to working with you this year. Thank you.
Nice to see you too.
Thank you, Representative Reckitt. Other questions from members of the committee? All right, it looks like everyone's all set. Thank you very much, Andrea, for being with us today.
Thank you.
And that brings us to our next presenter, which is the Maine Coalition Against Sexual Assault. And we have the director, Elizabeth Ward Saxel, who I believe is with us today. Welcome, and you can go ahead and speak, and then we'll have questions at the end.
Great. Thank you, Senator Carney and Representative Harnett, members of the committee, and of course, Peggy and Soupy. We all know who are the most important people in the room. And if you're new to the committee, if you haven't figured this out yet, you will. Thank you for providing me with the opportunity to join you today. As Senator Carney said, I'm Elizabeth Ward Saxel with the Maine Coalition Against Sexual Assault, frequently called MICASA. That will help you shorten it. Our mission is to end sexual violence and to ensure there are ongoing services for victims and survivors. I'm fortunate to have my colleague Jordan Henry with me today, who's our Systems Advocacy Coordinator, and he's going to help with running the presentation. According to Muskie's Crime Victimization Survey, each year approximately 14,000 Mainers will be the victims of sexual violence. 14,000 Mainers. Maine sexual assault service providers and children's advocacy centers exist to support survivors and those close to them on their path to healing, as well as to work to end sexual violence. If you've not yet connected with your local sexual assault support center to learn more about their work, I would encourage you to do that. They really love talking about it. Their programs are really much broader than you would anticipate. I know at least a few of you have attended some of their virtual open houses in recent days because I saw you there. But I'd encourage you to reach out if you weren't able to attend one of those, and they'd be happy to set up a time to talk more with you. At the most basic, MICASA exists to support those local programs through bringing their issues and expertise here to you at the virtual State House, and through providing training tools to them as well as to statewide partners. MICASA works towards ending violence through working in the 3 areas that you're about to see come up on your screen. It's worth noting that our public policy work is by far the smallest part of our work, and also obviously the most visible to you. So today I'm going to talk a little bit about our public policy work, but also spend a little time on the broader programming so that you can understand where the issues that come to you come from. For nearly 40 years, MICASA has worked to advise and assist this committee, the legislature, and the administration with public policy issues related to sexual violence. We work on a wide range of subjects, including child sexual abuse, human trafficking and sexual exploitation, sex offender management, elder sexual abuse, sexual harassment, and many others. When we are considering policy, we place a particular value on the voices and experiences of survivors, the professional expertise of sexual assault support centers, and also what the research tells us. And sometimes in this area, your gut is not right. The research is really important. And I just want to pause and echo the words of Ms. Sway and Mr. McKee, that one of the great pleasures of my doing this work with this committee and with the legislature is that we really work hard together as a group of people who care deeply about the integrity of our criminal justice and civil systems. And so, Mr. McKee and I often spend hours together trying to come to a consensus position, and I often feel on the end of it, on the other side of it, that we've come to a better solution. It's been my pleasure to work with your committee for more than 20 years. I'm proud of the life-changing work that you and your predecessors have done, including the creation of the Baxter Compensation Fund, abolishing the civil statute of limitations for child sexual abuse, expanding the scope of the protection from abuse statute to protect victims of sexual violence and elder abuse, creating first-in-the-nation housing protections for victims of sexual and domestic violence, and so much more. These laws have had an incalculable impact on individuals and the communities in which they live. And one of the pleasures of doing this work for me is that I get to see it really from the very beginning to the very end. And I'm sad that that's not always part of your experience, but this is the way it typically works. We hear from advocates and victims and, say, our partners at Pine Tree that individuals are experiencing sexual harassment by their landlords and are sometimes being evicted as a result of responding. We determine that one of the issues is the Human Rights Commission remedies come too late to keep that eviction from happening. We work with Pine Tree Legal to think through remedies. We look at what other states are doing. We talk with the Landlords Association about what their experience is and what they think about the best solutions for the problem. Ultimately, we bring a proposal to you, and you more often than not make it better. In this case, you added the ability to break the lease within 7 days as another remedy. It wasn't one we had originally proposed. And then the wonderful part for me is months later, I get a call from an attorney colleague at Pine Tree Legal telling me that they've just successfully used the new law to protect the victim from eviction. I get to see that full scope. What an extraordinary job we have. As part of our public policy work, we often don't have enough information to craft good policies and legislative remedies, and so we work with researchers to dig into complicated issues, like the rape kit study you see here. We also recently completed with them a study related to the commercial exploitation of children and policy solutions around that. And we're currently working on a multi-year project related to deferred disposition in sexual assault cases. We also produce an end-of-year legislative report, which covers all the bills that are related to sexual violence that are most key, and our statewide partners often use that. If you're interested in some light and really enjoyable reading, we've got more than a decade worth of these reports sitting on our website, so I encourage you to go and enjoy them. We also create a more tailored version of our legislative report for victim service providers called Implication for Advocates, that help them really understand what the new laws are and how they might impact their work on the ground working with survivors. I know many of you are familiar with the work that we do in your committee, now virtual committee, but actually the bulk of our public policy work is not with the legislature. It's with many boards, commissions, and working groups. The list that you see in front of you is actually just a portion of those groups on which we serve. These are standing groups that are appointed by a variety of folks, including the governor and by the legislature or the AG. So you can see the scope is wide. We anticipate there'll be a number of bills that are coming before you that you may be interested in. One of the key ones, I'm sorry I missed Ms. Mancuso's presentation. I'm almost certain that she highlighted the protection from abuse statute revision. Yes, I'm seeing this nod from the chair. Thank you, Madam Chair. We're thrilled about it. Particularly because the experience for sexual violence victims is because that piece of the statute was added on later. It's kind of like, I think of it as an old main house. You know, you add on the addition in the most expedient way, and ultimately it may not be entirely easy to understand what's going on with the architecture. That's certainly what's happened with the PFA bill. And we actually have judges, we have court clerks who have said, oh no, if you're a victim of sexual violence, it has to be by an intimate partner. And that is actually not true. So there are folks who have not gotten access to justice. Fortunately, they ultimately have as a result of Pine Tree Legal. Can't say enough about them, but that's been a challenge. There will also be a number of bills before you looking at the statute of limitations for child sexual abuse. There remains a small number of cases that are barred from accessing justice, and people are going to look at that. And also a bill to look at ways to make it easier for victims of child sexual abuse to provide testimony. And Andrea may have mentioned, we also are facing a major funding issue, and we're anticipating a bill to help address that issue. Otherwise, we're going to be in a place where we lose funds when we are in most need of supporting survivors. The bulk of this work that MICASA actually does is related to technical assistance and training for both our providers and for partners. Some examples of the training that we provide, we train all new correction staff on sexual assault. If folks are familiar with the Prison Rape Elimination Act, we're one of the folks who help train correction staff around that issue. We also train all new DHS child protective workers on the dynamics of child sexual exploitation. We coordinate the basic law enforcement training for cadets at the MCJA related to sexual assault. We work with Preble Street and our colleagues at the Maine Coalition to End Domestic Violence to provide human trafficking training across the state. The list goes on. Technical assistance is the other area that we spend a lot of time in, just kind of answering those questions that come up about how to deal with all the complexities around sexual violence. And a colleague of mine put this list together for me at the end recently, and I was just really blown away by the impact of the range of kinds of issues that it shows that we're working on. What's our obligation to protect the privacy of deceased patients? And in that particular case, it was related to a very serious criminal investigation where the survivor had died and the law enforcement was trying to get information from us, and we believe in victim confidentiality, and we were not interested in giving it up. But what's the dynamic for us when the victim's deceased? What should a survivor know before talking to the media? We actually have a several page handout now to kind of talk about those issues, wide range of issues. We also really work to create tools for our providers and partners. It does not make sense for folks to create one thing in their community all across the state. Our providers in particular are small nonprofit agencies with increasingly difficult funding environment. As a result, we make every effort to think about what services and trainings and products make sense to be created once through the coalition. So for example, this the poster that shows up last here is the one that's all across corrections facilities in the state. And in fact, they've actually painted it onto some walls at Maine State Prison about how to get support if you're a victim of sexual violence. We have great training tools for teachers. finally, I wanted to just talk a little bit about 3 particular programs. And we joke about what a program is in our office. And my assessment is if it has a website, it's a program, which is very flip and ridiculous. But also, these 3 things have websites. So they are definitely programs. One is Maine's Children's Advocacy Centers. I don't know how familiar folks are with those, but these are all across the state. We've only got 2 counties that are currently unserved, or they are served, but not by their own CAC. We hope to get those up and running soon. But in any case, these are focused on providing forensic interviews and support for families for victims of child sexual abuse. Jordan, would you move to the next one? So the way I like to describe CACs is what used to be the case for children who are disclosing child sexual abuse is, let's imagine they're in a school, they tell a teacher, the teacher talks with a guidance counselor about whether or not to make a mandated report to DHS. They make a mandated report to DHS. The DHS caseworker comes in, interviews the kid. Then maybe a law enforcement officer comes in, interviews the kid. Then the DA says, I didn't get all the questions answered that I wanted to get answered. So the DA interviews the kid. Now let's remember, this is a child who's potentially experiencing sexual abuse. Even telling that story once is really traumatic. And also, it creates clear evidentiary issues and so forth. So now what we have is one location with one highly trained forensic interviewer who is fed questions by all those disciplines in a child safety, friendly setting. And so now the kid is at the center, and the adult, the non-offending caregiver, is also getting the services that they need. The second of the 3 programs, I know sex trafficking continues to be an issue that the legislature is really interested in. So I just want to highlight our program MainSTEN, whose focus is on developing training, policy solutions, and best practices to support direct service providers across the state, as well as the multidisciplinary teams to respond to trafficking. So that includes our statewide trafficking training curriculum that I mentioned before with Preble Street MCDV as key partners, trafficking outreach materials for statewide use, and a statewide provider council that helps set statewide priorities and develop resources for more effective provision of victim services to victims of human trafficking. We also house the Maine Human Trafficking Survivors Fund, which in federal fiscal 20 served 106 unique survivors of human trafficking and sexual exploitation in Maine and met 142 individual emergency needs. The final of the 3 programs is the Children's Safety Partnership. 1 in 5 girls in Maine and 1 in 20 boys experience sexual abuse. In response to such prevalence, the legislature passed a law in 2015 that required that all school districts have 3 things in place: a written policy on child sexual abuse prevention and response, that every staff member, bus drivers to teachers to principals, have training on responding to child sexual abuse, and that every child receives some prevention education. The Children's Safety Partnership was created as a partnership between MICASA, the Maine Department of Education, and DHHS to support schools and communities in these efforts. Resources such as our activity book, Kids in Space, and educational programming from our providers exists for both students and personnel. And to this date, the training we've reached over 100 school districts and organizations. Whew, that's a lot of stuff. I'd be happy to answer any questions you might have. And I apologize for not providing you with a handout. I just could not decide what to put on one page. Presumably that's evident from the presentation I just gave. I don't know, I want to talk about it all.
You covered a lot of territory. Thank you very much. Is there a possibility that you could provide the slideshow to us in a PDF for members of the committee?
It would be my pleasure.
Thank you very much. Do members of we have a couple of minutes. Do members of the committee have any questions? I am not seeing any hands raised, so I think you covered.
Thank you for the opportunity.
Thank you very much. Our next presenter is the Maine Trial Lawyers Association. Chris Lewis and Kate Knox are here today, and I will let you introduce yourselves. And then if you want to have save a little time for questions at the end, I can facilitate that with the committee members. So thank you for being here today.
Thank you very much. Good afternoon. Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Chris Lewis. I'm the president of the Maine Trial Lawyers Association. Appreciate this opportunity to talk with you about our association and how we interact with your committee. The Maine Trial Lawyers Association, for those of you who don't know, was founded in the early 1960s as a professional trade organization. We represent about 600 individual attorneys across the state of Maine, from the top to the bottom of the state, top of the state to the bottom of the state. We are the state affiliates of the American Association for Justice. According to our mission statement, it's probably the best way I can summarize what we do and what we promote. We seek to promote and preserve the civil justice system, preserve the right to trial by jury, champion the cause of those who deserve redress for injury to person or property, to promote excellence in trial advocacy through training and education, to promote civility and professionalism in the bar, to influence and promote legislation consistent with our mission, support an independent and impartial judiciary, and to uphold the honor and dignity of the legal profession to the highest standards of ethical conduct and integrity. We'll talk about a couple things that we do, but I just wanted to point out we also provide robust continuing legal education for attorneys around the state, including concerning ethical issues and professional issues having to do with court appearances. We usually appear before this committee for one of two reasons, either to testify for or against legislation that impacts our civil justice system, the access to that system, or to provide testimony regarding judicial nominations. And just to let you know a little bit about how that works, before any judicial nomination testimony, we survey our members and then review the survey answers with our Board of Governors. Oftentimes, the Board of Governors has personal knowledge of the nominee. And then we report to you through testimony on the results of those surveys and any knowledge that our Board of Governors may have. As almost every facet of Maine's court system and Maine government as a whole, the civil justice system has been deeply affected by the COVID pandemic. We have worked with the judiciary closely over the past almost year now. It seems like a lot longer than that. Working to promote online video depositions, streamlining some of the processes and filing mechanisms to allow cases to still move forward. However, civil trials have been stymied in their ability to get to jury trial because of the COVID crisis. This will likely remain for a very long time, even as we start to get back to a new normal, the backlog of criminal and family matters needs to be dealt with. That is just, as I'm sure you've heard, I'm sure you're aware, it's a tremendous backlog. And we intend to work with the judiciary trying to get that through that process. But in the meantime, individuals and businesses across Maine are just in limbo, waiting for their day in court, waiting for their disputes to resolve. And a lot of times those disputes don't resolve until they're looking at a specific court date for trial. That's simply not happening right now. The Maine Trial Lawyers Association will advocate for a number of different mechanisms we hope will encourage resolution of these pending matters that have been pending for months and months and with no end in sight. We will be advocating for additional resources for the judiciary, including court staff and marshals, to help try to get through that backlog in both the criminal, family law, and civil jury system. Our association was really a resource for you, and we hope that you look at us that way. We have members across the state. We have members across a wide spectrum of legal practices. We hope that if you have a policy consideration or wish to understand how a particular piece of legislation might affect the civil justice system here in the state of Maine, you reach out. We will either respond to you directly or put you in touch with a lawyer on the ground, even a lawyer in your district who can answer those questions for you and hopefully provide you some real life examples of how these things are affecting regular Mainers. I want to thank you for this opportunity to address you. We've provided some written materials. I'm happy to answer any questions. And if there are no questions, I'm going to have our lobbyist, Kate Knox, address some specifics of legislative efforts that we're going to be advocating for in the coming months. Thank you.
Thank you. Does anybody have questions at this point, or would you like to wait until Ms. Knox finishes? I think we'll wait. Go ahead, Ms. Knox, and welcome.
Thank you.
Thank you, Senator Carney, Representative Harnett, members of the committee. It is really nice to see everybody's faces, even though we can't be all together. Chris, I'm an attorney at Bernstein Scher. I'm a lobbyist. I'm outside counsel, lobbying counsel to the MTLA, and have had that position for a few years now. Chris did a great job outlining sort of what MTLA does, how they function, and some of the general sort of priorities you're going to see from us this year. So I think of them sort of in three buckets. And the first is really what Chris talked about, is being supportive of increased funding to the court system. You heard from MacDole, you heard from a lot of people. There's just a struggle to get the courts the funding they need to function well. MTLA has particularly noticed the issue with the difficulty getting marshals to work in the courts. And so we've been communicative with the court system and offered our support for increased funding for marshals so that all sorts of trials and proceedings aren't held up by lack of that kind of staff. The second big issue that you'll hear from us today is connected to the struggle that everybody's having getting access to the courts. So what we did, what Chris noted to you, was we understand that civil trials in particular, it's going to take a long time to get that process back on track, to get the timing back on track, because we are farther down in the line than criminal trials and family work. So what we did was try to think about some other ways that we could encourage resolution of civil cases to get people resolution and justice appropriately. So you'll see we have an access to civil justice bill that'll be coming before you. It has three major components. One is it introduces the concept of third-party bad faith. So all of the let me say pre-trial, we see a lot of potential delays, and we see moments where there could be resolution and settlement, which are not taken advantage of because our laws don't necessarily encourage insurers to come to the table and act in good faith. So we have a third-party bad faith section. We have a prejudgment interest section, which says that your interest accrues from the time of injury, not at the time of resolution. And we also have a section on subrogation. Some of you will remember that back in 2011, I believe, then Governor LePage repealed subrogation, for payments under $20,000. And we worked closely with some of our members to take a look at that and are basically reintroducing the law that was in place prior to that repeal as part of this package. The hope is that with these things combined, it provides more flexibility in that potential pretrial phase. It encourages people to come to the table reasonably, obviously, and if we can encourage all the parties appropriately to really talk honestly about settlement, that will help alleviate some of the pressure on the civil justice system. It won't fix it, but it will certainly help. And then the last thing I would just highlight for you, which I know has been a conversation nationally and a little bit in state, is immunity, discussions around immunity for most particularly related to COVID. And the MTLA is paying close attention to this nationally and at the state level. We obviously strongly oppose any kind of push for immunity related to COVID illness. And I defer to Chris on this, but we already have very strong laws in place in terms of how workplaces need to function, in terms of how employers in particular are protected. And we would be concerned about extending immunity broadly for COVID. So you may see us in the middle of that conversation, and we'd be happy to, as Chris said, not only give you our take on things, but connect you with individual lawyers who have expertise and get you any information you need. So thank you for the time. And again, it's really nice to see everybody.
Thank you very much. I see a number of hands up. I'm going to call on Representative Harnett first because he may have to dash off to the AFA committee shortly, and then Representative Reckitt.
Thank you very much, Madam Chair, and thank you, Kate and Chris. First off, I applaud you for your efforts to try to increase alternative dispute resolution. Particularly, I mean, I think it's always a good idea, but particularly now with the demands on the court, it's even more important. Not a substitute, but sometimes a viable means for resolution. But I'm curious, have you seen an increase in mediations and arbitrations simply out of necessity since the courts have been in the predicament that they find themselves?
I'm happy to answer that, Representative Harnett. We have not seen, I don't believe, an increase in mediations. There's already a mandatory mediation process. I think the cases that we're going to settle get resolved there. It's the cases that need to go past that and need that trial date that we're seeing really hanging up, and they're just building. It's like a snowball. As far as arbitrations go, the MTLA historically does not promote arbitrations. The insurance companies don't like arbitrations for different reasons. So I've seen a couple of them personally. I'm just speaking for myself, my own practice. I have extensive civil litigation practice. We've seen a little bit of it. I haven't done any this year, but as far as mediations go, I haven't seen an increase.
Thank you.
Representative Reckitt, would you like to ask a question?
You spoke about immunity in on the issue of COVID. Are you also tangled up on the question, tangled into or up with or paying attention to the whole issue of qualified immunity?
I think we'll probably be taking a monitoring viewpoint and see what legislation's introduced, see if it's anything that we feel is within our purview and our mission statement, and we'll address it then. But considering I don't think any of those bills have been published yet, so we haven't had a chance to look at any of them.
Thank you. Somebody's got something because I'm getting calls. But
yes, there are quite a few. Yeah.
All right. Thank you, though.
Thank you, Representative Reckitt. Do other members of the committee have questions at this time? I am not seeing any other hands. Thank you so much for coming today.
Thank you very much. Appreciate your time.
Thank you for having us.
And our next presenter is Maine Equal Justice with Attorney Frank D'Alessandro presenting. You may go ahead. And if you want to save a little time for questions toward the end, I'll check in with committee members about questions.
Okay. My name is Frank D'Alessandro. Good afternoon, Senator Carney, Representative Harnett, and members of the Committee on Judiciary. I'm the Litigation and Policy Director for Maine Equal Justice. We're a civil legal services organization, and we work with and for people with low incomes seeking solutions to poverty through policy, education, and legal representation. And thank you for the opportunity to appear before you this morning. The first thing I would just like to say, I have done a lot of different things in my career. And one of the things I did was work in representing victims of domestic violence. And I just wanted to point out that Representative Lois Reckitt did not do herself justice. I had the honor of working with her for many years, and Representative Reckitt is a widely recognized nationwide leader in the struggle to access justice for victims of domestic violence. And it's not an overstatement to say that the protections that exist for victims of domestic violence would not be anywhere near as robust as they are but for her work. I've appeared, and Maine Equal Justice has appeared in front of this committee for many years. We've been able to work with committee members to achieve what we feel like are significant results for our clients. Just the last session, this committee, we worked on an act to provide relief to survivors of economic abuse, which you heard about other people testify about, which provided some really significant protections, especially in the area of collection by third-party debt collectors against victims of domestic violence who suffered economic abuse because of the acts of their abuser. We also worked to get an act to provide relief to survivors to protect tenants from sexual harassment, and that provided protections to tenants who had been sexually harassed by their landlords, to raise that as a defense in an eviction case and also to break a lease. And then this last session, we also worked on an act to require residential mortgage loan services to act in good faith in dealings with homeowners. And we were able to reach an agreement with other stakeholders, and that was also enacted in law, and that provides real protections to homeowners who are dealing with unscrupulous servicers. In addition to the policy work that we do when we work in legal services to individuals, this past year we provided services to over 650 households, mostly around public benefits and housing issues. This last year, we also have done a lot of work on unemployment cases, which we didn't previously do. We also work directly with administrative agencies such as the Department of Health and Human Services and Maine State Housing Authority on behalf of our clients. We work before municipalities that have a significant, when the issue has a significant impact on low-income people. And then we also do work before the judicial branch. And I'd like to echo some of the testimony you just heard about the challenges that the judicial branch is facing right now. And there are a number of issues there, but one of the issues is adequate funding for the judicial branch. And Maine's judicial branch, compared to other states, does not receive the same level of funding, and it does impact the access to justice, especially for low-income people. This past year, like everyone else, we've been impacted by COVID. Working from home right now, the legislature is appearing remotely. While I'm wearing a suit jacket, I don't typically do that. And so we've also changed our priorities as a result of the impact that COVID has had on low-income communities and communities of color and other minorities. We've changed, so we're much more, as a result of that experience, we have several bills which will not be in front of this committee, but which deal with access to healthcare, to make sure that people have access to healthcare in this really significant to deal with a significant crisis, and also homelessness prevention. We've done a lot of work on trying to get shelters up to be able to deal with the consequences of the COVID pandemic. And also we've experienced people, homelessness prevention is especially important now, as highlighted by COVID, because people who are evicted and become homeless are much more likely to experience the worst effects of the COVID pandemic. And so the bills we have that may come before this committee, some of the bills actually we were working on last session and they didn't finish because of what happened because of COVID and the legislature going out of session. So we have an act to increase protections for option contracts. That's a bill. So one of the predatory products out there that low-income people are targeted with are rent-to-own contracts, where someone will make a significant down payment on a home, and it's and they don't really have any interest in the property. So we have cases where someone will make $10,000, $20,000 down payment and then miss one rental payment and get thrown out. And this bill is designed to provide protections to people who enter into rental-owned contracts that are similar to foreclosure protections, so that someone doesn't lose the value of the entire value of the down payment they've made on the unit or the value of the improvements they've made to the property. Another bill that I think is likely to come in front of this committee is an act to enact the Maine Data Collection Protection Act. So right now, the judicial system is in the process of going to electronic filing, and that will create a great amount of electronically stored judicial records that are going to be easily accessible. In other states where this has happened, the experience has been that people, for example, who are involved in eviction cases are more or less blackballed from getting housing going forward if they're involved in an eviction case. And that's regardless of whether or not the tenant is successful in defending against the eviction case or the parties have reached an agreement that's acceptable to both parties. The mere fact that an eviction case was brought, regardless of the underlying facts, results in a blackballing of tenants. And so this bill would prevent landlords from denying a tenancy to someone who's been in an eviction case where there's been no finding where the tenant did anything wrong or where the tenant was actually successful in the eviction case. And it also provides some protections to people seeking employment and credit. Another bill that's likely to come in front of this committee is an act to expand the types of property exempt from attachment and execution. So right now, if you go to court and there's a judgment entered against you, the next step in the process is that the judgment creditor will then take you back to court and can attach your property, and in some cases force the sale of property. Maine has some of the lowest, so there are certain property is exempt from attachment. Maine has some of the lowest exemption amounts in the nation, and they have not been changed in decades. And so this would increase the protections for someone's primary residence or one vehicle that they need to go to work. And also, it would also increase. So right now, there's a difference between the federal minimum wage and the state minimum wage, and this would tie the amount that could be attached or garnished from someone's wages to the state minimum wage, which is significantly higher than the federal minimum wage, and would provide people with the resources that they need to keep housed and pay their basic necessities. There's also several pieces of housing
legislation that might come before this committee. There's an act to prevent homelessness by establishing an eviction mediation program that would provide protections to tenants in providing a more robust mediation program, which has traditionally been found to be to the benefit of both tenants and landlords. It would also provide information to tenants about what their rights are and what the procedure is. And it would also give the judiciary a greater role in deciding when mediation would be provided to tenants and landlords. And that may come before this this committee. And the other bill that might come before this committee is an act to prevent discrimination in housing based on a person's source of income. Right now, there are various programs throughout the state, including the Section 8 voucher program, which provide assistance to tenants. But there's no requirement that landlords participate in the program. And that results in low-income people not being able to find housing. For example, right now, there's approximately 500 households in the state of Maine that have Section 8 vouchers that can't find housing, even though they have the voucher. The value of those vouchers is about $3.5 million, and that's entirely federal money. And so Maine right now is faced with a very significant housing shortage for low-income and middle-income people. According to the Maine State Housing Authority, we would need 20,000 units in order to meet the demand. And given how serious that housing shortage problem, it's critical, and given the other budget shortfalls that we face going forward as a state, largely because of the COVID epidemic, it's really important that we take advantage of all resources that are out there. And this bill tries to do that. There are some other bills we're working on concerning around homelessness prevention. I'm not sure if they would come in front of this committee though. But I've had great experiences in the past working with this committee on both sides of the aisle, and I really hope to continue that this year. And be happy to answer any questions.
Thank you very much. Are there questions for Mr. D'Alessandro? I actually have two. If you could please, we've had a couple of the presenters today mention the economic abuse issue, and you mentioned it particularly in relation to debt collectors. Can you explain to us a little bit why that, what that phrase economic abuse means and the connection with the debt collection issue, please?
Sure. What economic abuse for the purposes of this statute refers to a situation in which someone who's a victim of involves someone who's a victim of domestic violence, and the person who abused them use their position of power to basically force the victim into entering into contracts or other legal obligations against their will. And so this bill amended the Protection from Abuse Act, which gave court judges the ability to make the abuser make the person who's a victim whole. The problem, but that wasn't enough, because the problem is often the abuser does not have the resources necessary to make that happen. And so in addition to that, there were two other provisions of the bill. One is that if the victim of domestic violence notified the debt collector that this debt was the result of economic abuse, that would prevent the debt collector from trying to collect that from the victim. They could still go against the abuser to collect the debt. And then the third part made it so that the debt could not be reported on someone's credit report. that third part is actually in litigation right now. We just filed, in fact, together with the Maine Commission to End Domestic Violence, we just filed an amicus brief with the First Circuit Court of Appeals on the issue of whether or not that section of the law on credit reporting was preempted by federal law.
Thank you for that clear explanation. We really appreciate it. And I see that Representative Reckitt has a question.
Well, the primary one I had was just answered milliseconds ago after in response to your question. But I wanted to ask just quickly, Frank, what the organization that you are connected with is primarily a policy organization. Do you do litigation on behalf of individuals or just, and I mean, what's the size of Maine Equal Justice?
Well, I hope I don't miss it. We have about 12 people on staff, but it's mostly a policy organization, but we also do engage in impact litigation. And we also have expanded recently to represent people who would not be eligible for assistance by other legal services organizations in the state, for low-income people who are not eligible for legal assistance by other providers like Pine Tree Legal. And so we have done more housing work for those people, for people who fit that, and also public benefit work, primarily around TANF, food stamps, and general assistance.
Thank you.
Could you also please mention the extensive work that Maine Equal Justice did in response to the pandemic with providing information about resources broadly to all members of the public on your website?
Yeah, sure. So actually, I did not mention this. We also have a community organizing arm and a communications arm. And we spend a lot of our time doing client education materials and also doing trainings to other providers and also individuals and community groups. And so we had, as a result of the COVID pandemic, we pretty quickly, as quickly as we could, and dramatically changed the focus of our work to deal with the impact of the pandemic on low-income people. And that did change the focus of our work. For example, prior to the pandemic, we did very little unemployment work, but as a result of the calls that we started getting and other providers started getting, we pivoted and started doing a lot of work on unemployment work, and we put out a number of client education pieces. And the other thing, because of the pandemic and because of the changes in what's happening in Washington at the federal level, there right now are there have been three major COVID bills, each slightly different and sometimes significantly different, which required us to rewrite the client ed pieces to be accurate. We felt it was really important to outreach to impacted communities to make sure that they knew what those changes were. And also, I think, as I mentioned, a lot of our work on homelessness prevention is a result of the impact of COVID on low-income people, especially communities of color, and how homelessness increases the risk of COVID infection.
Thank you very much.
Actually, the priorities for this legislative session are largely COVID informed.
Thank you. I see that Representative Babbage has his hand raised, and you will close out this introductory presentation. So go ahead.
Thank you, Madam Chair. Hello, Mr. D'Alessandro, and thanks again for being here and for all of your work. Correct me if I'm wrong. I was under the impression that Maine Equal Justice, well, years ago, I know Congress, decades ago, limited the population that could be served by legal services corporations, Pine Tree Legal and so forth. And I thought that was brought about the birth of Maine Equal Justice. But can you help me to understand what population is served by each? What's the delineation? And do you have any idea how many people in Maine are eligible to be served by Pine Tree Legal or your organization?
Well, so we try to focus on low-income Mainers, and by that we mean people with below 200% of poverty. Pine Tree has a very similar income eligibility standard, but they have, and I worked with Pine Tree for Pine Tree for many years, so it can be kind of complicated, but almost just about everyone who Pine Tree represents is at least below 200% of poverty, sometimes lower. There are some exceptions to that, but they're really rare and they're really in emergency situations. The major restriction on Pine Tree legal assistance that doesn't apply to Maine Equal Justice, one is that Pine Tree can't engage in class action litigation. Pine Tree can't do community organizing. And also Pine Tree, it's limited on who they can represent based upon immigration status. So for example, 2 summers ago, when there was a fairly large influx of people into Portland from the southern border, many of those people would not have been eligible for Pine Tree assistance. And actually that is when we took steps, Maine Equal Justice took steps to expand our ability to represent those individuals.
So if I could just ask to clarification, the separation line between your services versus Pine Tree Legal is not really an income, it's other kinds of restrictions.
It's not income based. In fact, the other, and I can't believe I forgot this, but the other major restriction on Pine Tree is that they cannot do lobbying, which is the policy piece that Maine Equal Justice does in the main thing we do.
Thank you, Madam Chair.
Thank you. And thank you, Mr. D'Alessandro, for being here today and for the work that Maine Equal Justice is doing. We have our next presenter I see is here and ready to go, and that is the Juvenile Justice Advisory Group. And I will just call, and I think several representatives are here, but we'll start with Jill Ward. And you can introduce everyone at this point, or however you'd like to spend the next 15 minutes. Welcome.
Thank you, Senator Carney and Representative Harnett and members of the committee. I am going to introduce my team that's come along with me. My name is Jill Ward, and my day job is running the Maine Center for Juvenile Policy and Law at the law school here in Maine, but I am also the newly elected chair of the Juvenile Justice Advisory Group, and I am joined by my vice chair, Ned Chester, Madam Secretary Christine Thibault, who serves on the body with me, and Linda Berry Potter, who is the Juvenile Justice Specialist and Compliance Monitor, which is one of the primary staff positions housed at the Department of Corrections in support of the Juvenile Justice Advisory Group. So I appreciate the time today to give you an overview of what the JJAG does, who we are, and a couple of quick reflections on what we've been up to for the last year or two. But I would really like to leave as much time for questions as possible from the body. I believe you got not a one-pager, but a fact sheet that's about 3 pages of who we are. And I'm just going to run through that sort of quickly with you all, and then we can pause for questions, and my colleagues can also join us in answering. So the JJAG is a construct of federal law. There is a federal statute passed originally in 1974 that set some very basic standards for the care and custody of youth in the juvenile justice system. And there are when I get into what we do, the Juvenile Justice Advisory Group was established by that statute to ensure compliance with this federal law, which is one of our primary responsibilities, and secondarily, to help make the plan for the federal dollars that come along with the ensuring compliance. So the goal of the original federal statute was to set these standards, but then also have a fiscal incentive for states to both stay in compliance with those standards, but then also provide resources to improve their juvenile justice systems in whatever ways that they designated. And the state advisory group serves in that advisory capacity to both monitor compliance and give guidance as to how federal dollars would be best spent in the state in accordance with a plan that is developed by the group and in accordance with the federal law. So it is an all-volunteer body that is appointed by the governor. In statute, it does delineate different types of individuals who should comprise the JJAG. They are 2-year terms, and the office that Linda is responsible for reporting up to is the Office of Juvenile Justice and Delinquency Prevention under the U.S. Department of Justice. The current member list, several new members, including myself, were just appointed by the governor this past July. And there's a link to the membership list that you can take a look at if you're curious as to the membership makeup. So what we do, as I said, we ensure compliance with the federal law, and there are 4 core protections of the act that states are to remain in compliance with to receive their federal allocation. And those 4 core protections are the deinstitutionalization of status offenders. So essentially not locking up kids who by virtue of their minor status would not be crimes if they were adults. So the most common examples of this, and you have this in your fact sheet, are truancy, running away, breaking curfew, those kinds of things. The second core protection is jail removal. And this is an incentive for states to keep youth out of jails and lockups with adults. There are some limited exceptions to this jail removal provision. Mostly, I think, at the time to accommodate rural areas that might have to detain a young person for a short amount of time in a jail setting because there was nowhere else to put them for before or after a court hearing. And then if there are unsafe travel conditions or acts of God or things like that, there are exceptions. And then the third protection, which is sort of a sub protection of the jail removal protection, is where you have those circumstances where you are temporarily co-locating a youth with an adult, you have to have complete sight and sound separation. So for instance, if you had to hold a child in a jail for transport for those sort of those little exception hours, you can't put them in a cell with an adult. And you can't have them in sight or sound contact with the adult. So you have, even where you are allowed to have a kid in a jail for a certain amount of time, you have to have sight and sound separation. And then the fourth protection is states are required to assess, identify, and then come up with a plan to address racial and ethnic disparities at all contact points of the system. So from arrest to confinement, coming up with strategies to reduce the racial and ethnic disparities that exist in the different points of the system. So as long as the state is in compliance, and Linda can speak to compliance, as long as the state is in compliance with those core protections, the state gets an allocation of federal dollars. And the second major task of the JJAG is to develop a 3-year plan to spend those dollars. And that plan has to be in accordance with both the federal law and also with, ideally, in conjunction with the members of the JJAG who are using the federal dollars to augment what the state is doing to improve its juvenile justice system. The allocation is a formula grant. It's based on the number of 18-year-olds or 18 and under in the state. But there is a floor guaranteed minimum right now in statute of at least $400,000 that comes to each state at a minimum. And that's where Maine has generally been for the last several years. Funding, this is the funding that is also withheld if there is non-compliance with those 4 core protections I just outlined. In Maine, I guess I'll talk about what we've most recently used the money for, and many of you are, I think, very familiar with this, is large systems improvement work. as the federal allocation has dropped over the years, although now it's starting to tick up again, the JJAG had made a decision to really focus on systems improvement investment, as opposed to sort of a lot of little tiny grants to do one sort of big investment in large systemic change. And one of the outcomes of that, or a couple of the outcomes of that, are things that money has been spent on in the last 4 to 5 years, which include the audit of Long Creek, and then most recently, the Children's Center on Policy and Law's juvenile justice system assessment and report that was released last February. So those things were funded by the JJAG, those major sort of pieces of research to inform juvenile justice work and reform were funded by this body in accordance with the prior 3-year plans. And then I would just say, we're now in the sort of phase of a new 3-year plan. We haven't got yet the solicitation from OJJDP to submit our new 3-year plan, but we have been working on that for the last several months, and I've outlined a plan that reflects many of the recommendations that came out of that CCLP report and other ongoing work that the JJAG has been involved in. And then I would say the third sort of bucket of things that the JJAG does and can do is it serves as an advisory body to the governor, to you all in the legislature, and really to anyone who is interested in engaging us in getting information about what is happening in Maine, what some of the best practices are, what are the needs in Maine. We are sort of an advisory body in that sense and can provide that kind of information as requested. So I'm going to take a deep breath and pause. And Ned was the chair before me, so it's very intimidating to have my predecessor here to listen to the spiel of what we do. But we are looking at an appropriation for this year of around, I think, $432,000. Linda can correct me. And we have some prior federal dollars in the pipeline that have yet to be spent. So we are really engaged very intensively right now in developing this 3-year plan in a way that really targets the federal resources in line with what work is already being done in the state, both with the Department of Corrections, DHHS, and other agencies who are involved in meeting the needs of this population.
Thank you very much. Do other representatives of JJAG have contributions to make at this point, or should I ask for questions?
I'd like to chime in. I'm a compliance monitor and acting juvenile justice specialist. Actually, wanted to say when our members are appointed by the governor, the term is 4 years. It's our chairs and vice chairs that are a 2-year rotation on that. Part of the 3-year solicitation, as Jill referenced, I just want you to know it encompasses 32 different items that the JJAG and myself have to address in order to be eligible for those funds. And that not only is the core protections, but it's also some things like the use of restraints on juveniles, the use of restraints on pregnant juveniles, and all the way through to how many juveniles are getting put into the adult system, which I'm happy to say here in Maine for the last 2 years has been 0. And I did want people to know that we do have what's called 2 rural exceptions, and those are 2 jails that are inspected annually to make sure that they are in compliance. I was very happy to tell after last year's compliance check that they not only are in compliance, but they actually exceed the levels that the federal government asked us to be at. So I think that speaks very well of the professionalism in Maine. I'd also like you to know that our last violation of the Core Act was in 2018. And that was, they had put into a detention center a young girl who had run away from a program, not realizing that running away was a status offense. And our resolution of that was training for that police department, and there have been no violations since. Thank you.
I would just like to say very briefly, because I'm interested in your questions. that the fact that Christine Tebow, who is a juvenile prosecutor, and I, who have focused my practice for the last 35 years on defending juvenile, the fact that we are both on the JAG is just kind of the tip of the iceberg. We represent all viewpoints. I mean, we really have an amazing group of people working on this now. And it's a great spot for us to come to consensus or battle out issues that need to be battled out. But JAG represents a very kind of broad range of people who are interested in juvenile justice issues in Maine.
Thank you very much. We do have a couple of minutes. Well, first, Ms. Tebow, would you like to speak?
I think everything's been covered. Just to give you some historical context, our allocation in Maine, as Ms. Ward mentioned, is about $430,000 annually. When I began with the JAG in early 2000s, we received collectively from OJJDP about 1.2 million. So one of the things that we continue to do as part of the JJAG is be part of a national organization called the Coalition for Juvenile Justice, which is a consortium of other state advisory groups working together to make national reform efforts as well, and to keep the act fully functional, and to hopefully increase appropriations and get back closer to where we were 20 years ago. So we work on the state level, but we also are part of a broader national initiative to raise up juvenile justice issues.
Great, thank you. We probably have time for one question. Does any member of the committee have a question? I'm not seeing any hands. Last call. All right, I think that you were so thorough, you covered it all. Thank you for your presentation today.
Thanks for your time.
And now we'll move on to our last presenter before we take a short break. And that is a review or an overview of the Criminal History Record Information Act and Intelligence and Investigative Information Record Act with Chris Parr, who is with the Maine State Police Department of Public Safety.
Hi there, good afternoon.
Welcome.
Representative, can you hear me okay?
Yeah, we hear you fine.
Okay, great. Representative Harnett, Senator Carney, nice to see you. I know some of you on the committee, and it's great to see you as well. And I look forward to working with and meeting those of you who I have not met. My name is Chris Parr. I'm a staff attorney for the Maine State Police. I'm also the legislative coordinator for the Maine Department of Public Safety. I've been in my position for just over 15 years now. I've worked with both of these statutes for over 15 years. And I have to say, I learn about aspects of them every day, even up till today. And so I do not expect after this presentation that you'll have a thorough understanding by any means of these statutes. But I do want to say, just really give an overview, sort of a working knowledge of these. The two most important things that I guess you would, I hope you take from today is number one, Peggy Reinsch and Sue Panett are awesome. They're excellent. And you're very fortunate to have them working for your committee. Number two, there is a difference between criminal history record information and intelligence and investigative record information. And they are different as a matter of legal definition. They are mutually exclusive. So often you might say, well, I want to see your police records, or you might hear that. And in this case, the distinction is this. There aren't just police records in that sort of sense that you might hear sort of talked about. There is criminal history record information. And I did send, of course, those handouts. I won't go over them. Hopefully you'll have a chance to look at those because those might be helpful. But there's criminal history record information, and that's otherwise often called a rap sheet. It's probably the closest you'll ever come to something that would be the permanent record that you always hear about when you're in school. This is going to go down on your permanent record. Well, this is probably the closest that you'll come to that, at least from the criminal justice system standpoint. And then the intelligence and investigative record information, that, for lack of a better sort of description, are the police reports and other evidence, other documents that tell the story about the matter that ends up on the permanent record, in the criminal history record information record. And to use I know I sent out a handout that showed sort of some icebergs to show how these information relate to each other and the proportion of information that's involved. But another way to think of this is that criminal history record information is like the table of contents of a book. The intelligence and investigative record information are the chapters of the book and all the words of that tell the story of each incident that's accounted for in the table of contents, which is basically usually just a summary. Three important points I would make. Both of these types of information, they will often do follow people around once they're publicly disclosed, especially in this day and age of the internet. And in fact, even confirming the existence of this type, both criminal history record information and intelligence and investigative record information, even confirming the existence can cast a cloud over someone and cause harm to their reputation, their privacy interests, even potentially endanger people in some cases. The other thing to keep in mind is that this is, of course, these are types of information. And in this world that we're living in, information is now a commodity. Information has a lot of power. And we do have occasion where people are seeking out, certainly in the case of police reports to find out, so what can I find out about this person that might help me in, say, some litigation or something. And we have had at least one instance where there was information being sought about candidates for a candidate for office. And so there is an interest, and there's going to be more of an interest, I would anticipate, in trying to access this information. The last thing I would say is that it amazes me the amount of information that in the position that I hold, I see the state take in, and certainly the state police who I work for take in, extremely personal, extremely sensitive information. And one of the things I've come to really realize that as a public servant, it's important for me anyway, and I would say for all public servants, to be good stewards of the information that the state takes in and maintains, especially when it's as sensitive as this information can be. The thing about intelligence and investigative record information, I would add, is that by statute, such information and records that contain such information is confidential. However, the disclosure of such information, it is possible that some information can be disclosed, but only if certain harms that are identified in statute in Title 16, Chapter 9, if those one or more of those harms would not result from that public disclosure. Likewise, criminal history record information, you have public criminal history record information, and then you have confidential criminal history record information. And so there is some degree of protection right now with respect to these types of information, but there is, at least in the case of criminal history record information, a public aspect that can be accessed. So I intended to keep my presentation short. I would encourage you, if you haven't looked at the handouts that I sent out before, I would encourage you to look at those. And certainly don't hesitate to contact me if I can be of any help at all on any matter. and especially with regard to questions about these statutes and these types of information. Thank you.
Thank you very much. And I see that we have one question, and I'll ask other legislators who have a question to please use the raise hand function. Representative Reckitt, why don't you go ahead with your question?
I'm curious, Chris, and I'm sure others who have employed people have been in a position where they either wanted to or were mandated to do a criminal history records check on somebody they were going to hire. Which basket of information is that when were we to order such a thing and pay the fee to get it? I might.
Yeah, no, it's a great question. Typically for agencies that are not law enforcement or other criminal justice agencies, businesses, for example, can request the public criminal history record information, and they can do that online through a website that's maintained by the State Bureau of Identification, which is part of the Maine State Police. The other types of information, as far as confidential criminal history record information, that would be accessible to law enforcement, including law enforcement agencies who might be looking to hire someone to be a sworn law enforcement officer. But generally speaking, to answer your question, it's public criminal history record information that would be made available to anyone in the general public, basically.
Just a follow up, these are not just Maine-based information, are they, or are they? I mean, is this a national record?
The requests that I believe, and I'll say this, another person who I would encourage you to invite at some point if you have time is Matt Ruel, who's the director of SBI here at State Police. He's much more knowledgeable than me on these. I believe, though, that when you make an inquiry through the online website through SBI, you're getting only the main information. If you wanted sort of a federal query to be made that would be fingerprint supported, I believe that's something that has to be sent to the FBI.
Is that what's done with by the Academy and police hiring? Is a national records check done, or just
I believe so, but I can check on that and let you know. Definitely.
Thank you.
Do other committee members have questions they'd like to ask? Looks like Representative Babbage, do you have a question?
Thank you very much. I was just reaching for the raise hand part there. Thank you very much, Madam Chair. Mr. Parr, great to see you again. And if I didn't ever express it during the Right to Know Committee, I very much appreciate the expertise and perspective you bring to that committee and to wherever you serve. And I think we had a common concern in the area of the weaponization of information. And since 2001, there's been a real emphasis on agencies sharing information and being more efficient with the sharing of information. Obviously, I'm concerned about those that mine information for commercial benefit. But even within the law enforcement community, when we talk about the two levels of information that you have described to us, and MIAC, are there safeguards even within the community of not retrieving information for other than valid reasons?
Yeah, I mean, certainly as a matter, there's a federal regulation, 28 CFR Part 23, that controls the intelligence and investigative record information, also controls investigative information that could be involved. The criminal history record information, likewise, would control types of information. And we also we do have a privacy policy in place for the MIAC itself. So there is, this is something that, as you know, I'm personally a personal privacy advocate. And I take that role and that view of information extremely seriously. So I hope that answers your question.
Yeah, thank you.
Do other members of the committee have questions? Yes, Representative Poirier.
Thank you, Madam Chair. And this is more for clarification. You might have touched on it a little bit, but just as far as the intelligence and investigative information, if a person is accused of something and they are investigated, but it never becomes part of their criminal record, is that investigative information still in those sort of reports and accessible, or how does that work?
It's a great question. If someone is investigated, for example, a type of confidential criminal history record information, one type of that would fall within that definition is a decision not to refer something or not to charge someone. Okay, so that by definition, that fact in itself would need to be treated as confidential and not, it would not go out on the public criminal history record information report. But so you would still have the information. If it was trying to imagine a situation where that would be included on the actual record, I can't think of one off the top of my head. If it didn't even get charged, but the thing to keep in mind is that you still have potentially a tremendous amount of investigative record information that's associated with that case that is held by the law enforcement agency that investigated. So, in that information, again, the fact of an investigation, as I was mentioning earlier, can put a cloud over someone and unjustly. And so there are right now in place in the law, there is a mechanism to basically make it so that law enforcement agencies can't confirm the existence or non-existence of that, because if someone has a public record, a public criminal history record that it has nothing on it, but a person can still find out by inquiring a law enforcement agency, hey, do you have any records of investigations relating to this person? That can still cause damage to someone, just the mere fact that oh yeah, we investigated this person, but we can't provide it to you. But just the fact that we've confirmed it can potentially affect someone negatively. And so that's just something that's a great question, something to keep in mind.
Thank you.
Looks like we're just about in time for our brief afternoon break. Do any committee members have additional questions before we thank Mr. Parr? Looks like we're all set. Thank you very much, Mr. Parr, for being here. And committee members, we had a 15-minute break scheduled. We're 5 minutes over. Is everybody comfortable coming back at 2:30? Let's see, nodding heads. Is anybody not comfortable? Looks like that's okay. So please turn off your video and mute yourselves during the break, and we'll see you back at 2:30. Thank you, everyone. Hi there. Just wanted to let you know that we're going to start up in a few minutes. Committee members are returning from a much needed break, and it'll just be a minute or two. I forgot to unmute myself. All right. Looks like a good number of us are back in the meeting. And so we will start with our final 4 presentations of the afternoon. And we begin first with the County Commissioners Association and Steve Gordon, who's here with us today. And Mr. Gordon, if you'd like to take questions at the end, you can leave some time for questions. Thank you. He may not be here with us quite yet. We'll give him a moment to return. Mr. Cohen, are you also part of the County Commissioners Association? Oh, you're muted.
Sorry. Yes, I am, Madam Chair. I'm just texting Commissioner Gordon right now. I saw his picture up there and he was on mute and now he's disappeared. So I will send him another quick text. I apologize.
No, that's fine. Thank you.
I know he was having computer trouble. If it turns out he doesn't return in a minute, I'd maybe suggest that you move on to your next if you can, so that we don't delay your proceedings.
Okay, I don't know that our next presenter has joined us yet. So we'll wait a minute. The technical difficulties happen. We can be patient.
Thank you.
Mr. Caverly, if the County Commissioners Association is delayed, would you be able to start your presentation now?
Absolutely, Madam Chair. I was listening in on the YouTube channel, so I sprung into action.
Thank you. Jim, what is your preference?
Yeah, actually, I have Commissioner Gordon on the line. He's having technical difficulties, but if Mr. Caverly is ready to go, that would be great. And then we can perhaps join afterwards, if that's okay.
Yes, that sounds like a great plan. All right, thank you very much.
Great, thank you.
Yeah, Mr. Caverly, why don't you go ahead and welcome to the committee, and I'll just do a quick introduction. This is Rob Caverly from the Maine Credit Union League.
Thank you, Madam Chair, Chair Carney, Representative Harnett, and distinguished members of the committee. My name is Robert Caverly, and I'm the Vice President of Governmental Affairs with the Maine Credit Union League. I had a nice fancy handout in the works for you folks, and COVID got in the way, so it's not ready. So I apologize. You're just gonna have my voice for now. So, so obviously, sometimes you'll see me in the hallways representing the league. More often than not, we are represented by Ed and Kate Pino in the hallways. And sometimes my colleague Ellen Parent, who works with us at the league, has been known to testify before this committee on some bills. So a little bit about the league. The Maine Credit Union League represents all of Maine's 54 credit unions, which have about $9.6 billion in total assets and have over 725,000 members as a part of their credit union, as a part of the credit union system. Maine credit unions have nearly 200 branches and employ over 2,300 people across our state. As probably many of you know, but I'll touch on very lightly, the foundation of credit unions is really what sets us apart. Credit unions are financial co-ops, meaning that the credit union is not owned by shareholders, but rather by the members of the credit union themselves. Because of the structure, profits generated by the credit union are given back to the membership through dividends, better interest rates, lower fees, and other member benefits. Each credit union is governed by a volunteer board of directors, and Maine credit unions work every day to embody the credit union philosophy of people helping people. And to that end, we're very pleased to announce that since 1990, the league and our credit unions have been working on what we call our Ending Hunger campaign. We raise money to support local food pantries and other efforts. And this year, we've accumulatively have exceeded $10 million raised for that campaign. So we're very proud of those efforts.
That's very remarkable. Thank you for all your.
Thank you, Senator. So as I said, the foundation of the credit union movement is what sets us apart in the financial services industry. Credit unions are often trying to find the solutions for the unbanked or the underserved, whether it's trying to find financial solutions for the challenges that are faced by new Mainers, finding alternatives to predatory payday loans, or creating financing options for those looking to expand their career. Maine credit unions are also there to, to improve the financial lives of all Mainers. This past year, as the pandemic has changed all of the way we operate, the Maine credit unions, every single credit union in Maine has stepped up to do something to help their membership take on the economic challenges presented by the pandemic. Some credit unions have participated in the federal government's Paycheck Protection Program. Of course, everyone knows that as the PPP program. And many other credit unions have offered skip-a-pay options to their members, loan restructuring, forbearances, refinancing, and other forms of assistance to their members as we all work to get through this challenging time. So some of the issues that we will be watching and participating with this committee on, many bills, any bills dealing with the probate code, we may not actively participate, but we're certainly watching and keeping an eye on. Another issue that has come up before this committee in the past, criminal history and background checks while folks seeking employment. So credit unions, like our colleagues in the banking community, we have strict federal regulations that we must adhere to in our hiring processes. And those protections are there to protect consumers and the soundness and safety of our financial institutions. So that doesn't mean that the league is unsympathetic to the cause that is usually brought to the committee in helping folks get that second chance and get a path to employment and remove those barriers. In fact, the league is often looking to participate and assist those types of folks in getting into society and into the workforce. So, however, it is those federal regulations that sometimes mean that we participate or have to ask for carve-outs in legislation to make sure that our hiring practices aren't impacted. And probably the number one issue that the league has regularly appeared before the Judiciary Committee in the past is on foreclosure. Maine's foreclosure laws are a bit of a mixed bag. The foreclosure process in Maine can be very lengthy, both in time and resources. This long process can end up hurting both the homeowner and the financial institution. And in the case of credit unions, again, it's the members who own the credit union. So those are the folks that can sometimes be impacted by these long processes. Consumer advocates have argued correctly that Mainers need to be protected from out-of-state bad actors that can prey upon Mainers and have created problems in the past, like we saw last decade with the Great Recession and the housing market crash. We do not disagree that we need those protections. However, the same laws and regulations that are designed to protect homeowners from those bad actors are also applied to our local Maine financial institutions. And the league is constantly looking to help this committee and policymakers to find a way to strike a balance between continuing to protect Mainers from bad actors while also protecting Maine financial institutions. I've often heard many credit union leaders in my relatively short time at the league. They've told me that they are firmly in the foreclosure prevention business, meaning that credit unions are well known for their hard work, their dedication, and trying to go above and beyond to keep their members in their homes. So to this end, we will continue to be open on this particular issue and others, and engage with interested parties as bills come before this committee. So I will start the close there and just thank you for your time. But more importantly, thank you for your service, not just to this committee, but also to the institution. For those who don't know me, I was Chief of Staff to Senate President Mike Thibodeau at the State House. So I understand the challenges and the burdens that legislators face and the time commitment that you all put into this. And I thank you for that. It is kind of interesting times. If you would have told me that we'd be conducting these transactions virtually, I may have bought that, but I'm not sure I would have bought, seeing Representative Babbage and myself wearing headphones and thinking that that's appropriate for legislative processes. So it is an interesting world that we live in. Anyway, I thank you for your time. Happy to answer any brief questions, and we look forward to working with you in the 130th Maine Legislature.
Thank you very much. Committee members, does anybody have a question for Mr. Beverly? I am not seeing any hands.
It's because the presentation was that good.
Oh, wait a second. We do have a question. It was good, and we have Representative Reckitt. Go ahead.
Whoop. On mute.
Are you having trouble? Let me see if I can unmute you from here.
Anyway, I'm a credit union member, and so I'm concerned about sort of on the ground stuff. You said there's approximately approaching 200 credit unions in the state. Branches in the state. Okay.
Yeah.
And that makes more sense. And my question is, what do you know? What percentage of them are fully open at this point, or?
Yeah, so that's a great question. And actually, I might add a little extra color to that as well. So soon after COVID hit, the league and our partners at the Maine Bankers Association set up weekly calls where we've been kind of communicating with each other back and forth of how the industry's been performing and the challenges that we've been facing. And I will speak certainly for the league, but I suspect that I can very, very loosely speak for the Bankers Association on this as well. Well over half of our members, and more like 75% and beyond, have closed their branches or doing appointment only at this time. And that's largely just to try to do our part to keep our staff safe, keep the community safe. So yeah, it's the vast majority of branches are closed to the general public, and many are open by appointment only. And again, working with the Maine Bankers Association on this has been a positive, as we've made sure that the industry is trying to put out the same messages and working together. And we thank them for that cooperation. In many states, it's the bankers and the credit unions are like the Hatfields and McCoys, but in Maine, it's not quite that bad. So that's good.
So, so is that the other thing that appears to me not to? I deal with 2 credit unions a week. There's no reason to, and I'm not a member of both, but one of them does drive-through. The other one, I go inside the branch to do my version of shared banking because you all aren't doing shared banking anymore. Is that a temporary thing during the crisis? This is
yeah. So I'm gonna get out on thin ice here pretty quickly, but my understanding, Representative, is that a lot of those policies are set by the credit unions themselves. So one of the challenges that we had initially that you've just touched on as the pandemic hit is obviously shared branching. And shared branching used to kind of be a requirement that folks go into the branch, that you couldn't use the drive-through for shared branching. Some institutions, I believe, had allowed shared branching to happen through the drive-through, but again, it's been in a credit union by credit union basis on the comfort level that credit union has with offering that service, whether it's a requirement that folks continue to go in, or if they are allowing those transactions to happen via the drive-through.
Thank you.
Yep.
Thank you very much. Any other questions from members of the committee? Representative Babbage, go ahead.
Yeah, thank you. I'll just briefly mention to my headphone colleague, thank you for being here. And I can't believe after 2 terms on EUT that I'm not going to take the opportunity to grill Jim Cohen. But I do want to say to when my wife got her $600 check, we actually had to physically go to the credit union in Biddeford, and I wanted to thank Mr. Cavalier for what was our first social outing in 10 days. So, but the credit union has been a great thing to be affiliated with over 4 decades, and I appreciate your position and service. Thanks.
Thank you, Representative Babbage. I didn't see you on video earlier. I was going to add that a little while ago, Representative Babbage taught me one of the most important legislative lessons. I may or may not have been a participant in a model state program, which Representative Babbage is well known for. And I remember him standing up at the rostrum at the House, and he took the gavel and he whacked it. And he said, "Congratulations, you all just voted yes. Let that be a lesson to you." I've never forgotten it.
That's great. Well, thank you very much, Mr. Caverly, for being here. It does not look like there are other questions. Are there further questions?
I did have one correction. My colleague Ellen Parent has been texting me because she keeps me on. I said that branches were closed. That is incorrect. Lobbies are closed, not branches. So small distinction, but we'll make sure we're factually correct.
Great. Thank you very much. And I'm just going to check it. Well, first, before we move on, We have been joined by our committee member, David Hagan. Representative Hagan, would you like to introduce yourself?
Thank you very much, Madam Chair. I'm David Hagan. I represent House District 101, Hamden and Newburgh.
Thank you. And let's see, I want to check in with the County Commissioners Association.
Thank you, Madam Chair. And I have received a text from Commissioner Gordon that his computer is unfortunately hopelessly frozen, and he asked whether I could cover. And I could, of course, never fill his shoes, but I'd be happy to spend a couple of minutes just at a very high level talking about the association, if that is okay with the chair and the committee.
We would appreciate that. Thank you very much.
Thank you. And I am also glad that Representative Babbage will have an opportunity to grill me at the conclusion of my brief remarks, which is something I always enjoyed in the Energy Committee. And so very briefly, my name is Jim Cohen. I am an attorney with Farrell Dana, and I was before you a couple of days ago, but I'm new to working with the County Commissioners Association, but I'm not new to counties. During the 6 years I spent on the Portland City Council, I spent 3 of those years as a member of the Cumberland County Budget Advisory Committee. I chaired it for a year in 2005. So I got a chance to learn firsthand about counties. And then when my wife served in the legislature, she chaired the Cumberland County delegation in 2009 and 2010. The County Commissioners Association is made up of representatives of 15 of the 16 counties, and the commissioners meet weekly to discuss legislative matters through a legislative policy committee, and monthly the full board will meet to discuss issues related to legislation and otherwise. What I describe as counties is law and order. So the subject matters that counties are involved in on a regional basis. On the law side, the sheriff's departments cover obviously law enforcement, and then on the corrections side, county jails. Some jails are shared among counties, but both functions are probably the largest single budget item of a county. In addition to those, to sheriffs and corrections, the Registry of Deeds and the Registry of Probate, as well as probate judges, are part of county government. And then budgets for the district attorney and some of the district courts also go through the counties. The issues that the Maine County Commissioners Association focus on that would be most relevant to this committee would include some probate issues, some deed issues, and maybe issues that relate to courts. The piece that, and I'm trying to channel my inner Steve Gordon of what is most important to counties, because the jails represent such a major part of county government, and the tax money that goes to support jails as well as other county functions are ultimately a pass-through item on the municipal tax bill. The counties are obviously very sensitive to what it costs to operate jails. And what's interesting is LD1, which municipalities live under and require certain expenditure limits. Municipalities have the ability to exceed those expenditure limits by a majority vote of their council. And counties have the ability to do that too for most of their functions, except jails. For jails, it's actually a hard cap that counties cannot exceed. So one of the challenges is that as new services are needed, if expenditures need to be higher than that cap, counties are very constrained in terms of dealing with that. The other point that I wanted to bring across that Steve has certainly mentioned to me and the commissioners have talked about quite a bit is what is the appropriate function of jails? Obviously, we have inmates there for a variety of reasons, generally for short terms. Some are awaiting trial. Others are there for misdemeanor offenses or small felonies, but short term. And most of the inmates who arrive, many of them are on psychotropic medication. There's a large number of inmates who also have co-occurring behavioral disorders, substance use disorder, and need treatment. And what's interesting is that when an inmate arrives at a jail, to some degree, that is an indication that something else in the overall system, some of which are issues that come before this committee, something isn't working right. That treatment hasn't worked right, that inmates haven't been appropriately diverted to other options other than jail, that behavior has been criminalized, and whether it should or shouldn't be criminalized becomes important. And we don't have any single answers. There's no silver bullet to all of this. But I guess our message is all of the matters that relate to the health of people, the treatment of people's disorders, what's criminal, what the sentences are, ultimately flow down to the jails, the discretion of prosecutors, the discretion of law enforcement officials, and when an individual is in jail, the jails and the counties do their best to work with them. But to the extent we can divert people from going to jail in the first place, that's something that I think all of us should be thinking about. So hopefully I've done my best to channel my inner Steve Gordon, Commissioner Gordon, and appreciate the opportunity to be here today.
Thank you, and thanks for stepping in on such short notice on his behalf. You gave us a lot of great information. Committee members, does anybody have a question for Mr. Cohen? Representative Babbage?
Yes, thanks. I won't grill, but I do have a legitimate inquiry. Good to see you, Jim. Over the years, there's been talk of consolidation of corrections, state and county, and I know that makes a lot of people shudder. But I would be interested sometime, if that's too big a question for you to reflect on. But I also am interested in COVID in the jails. We just heard yesterday that among staff members, for instance, 1,300 staff members, 65 have COVID in the state correction system. And I wondered how the county jails were dealing with COVID and how much. So if at some point you might be able to share those numbers with us, I'd appreciate that. And of course, as far as those that are institutionalized as well. Yeah, thanks.
No, I appreciate that, Representative, and those are both important issues. I don't have hard answers to either today, but certainly be happy to try to get back to the committee and yourself with some of the information. I've certainly been aware that there have been outbreaks periodically in some of the jails, and people are in close quarters. I think the jails work hard to try to make sure that the inmates are protected, but in close quarters it's difficult. But I'll try to get that number for you. In terms of jail consolidation, that was an active conversation 10 plus years ago, and the current system is a partnership between the state and the Department of Corrections and the county jails, where the state provides a certain level of funding and has some oversight. And that money is used to help support and create some efficiencies among jails. So at this point, consolidating jails in terms of closing them, I'm not aware that that's a conversation occurring, but that finding efficiencies is something that has been a discussion, and I'd be very happy on that as well to get back to you and other members of the committee with more information on that.
Thank you very much. Representative Harnett and then Representative Breckett.
Thank you very much, Madam Chair, and thank you, Jim. I hope that Madam Chair has noted that I use the electronic hand raising feature, and that's because I'm no longer a co-host. I'm just a participant, so I may need to learn some other tricks as a co-host.
Well done.
This is more of an observation, but Jim, you mentioned that, and I'm putting I was the mayor in Gardner for 6 years before I served in the legislature. And one of the things you said is that the cost of the county jails is a direct pass through the municipality to the shoulders of the property tax payer. And it's important for this committee and also for the Criminal Justice Committee to keep that in mind when they are making decisions about all the things you spoke about. Who is being incarcerated? How long are they being held for? Do they really need to be in a county jail? Because not only do those decisions that we make statutorily have real human consequences to the persons who might find themselves in a county jail, but they also have real economic consequences to every municipality in the state and every property taxpayer in the state. So I just want to thank you for highlighting that.
No, thank you, Representative. And I certainly know that as a municipal representative on the County Budget Advisory Committee, that was very high in my mind. And I remember once asking a question of then Sheriff Mark Dion about why certain elements were being passed through to Portland taxpayers. And a month later, Sheriff Dion produced what he described as the Cohen memo, laying out all the terms and reasons why Portland needed to pay its fair share, but obviously a very important issue.
Thank you very much. Representative Reckitt?
Yeah, I just wanted to let the committee give some information to the committee. I've been working with Commissioner Gordon, and at his bequest, or behest rather, not bequest, at his behest, I've submitted a bill that updates certain probate filing fees to reflect current costs. So the probate filing fees will go up by $20 on the low end and $250 if your estate's worth more than 2 million. So that won't bother me. So hopefully not too many others. The other is that there is one of the other things that in one of the bills that I've sponsored this year is to add a county seat to the county corrections kind of seat, not a county, I don't know, it's commissioner or just a county representative on the Criminal Justice Board of Trustees of the Academy. So that because the jails are being paid for essentially by county government, we decided that it would be a good idea to at least discuss having a representative of county government on the Criminal Justice Academy Board that certifies and does all that stuff with jails and corrections officers. So both of those things, I'm sure the second one will be coming to criminal justice, but the probate filing fees will probably come to the Judiciary Committee, I would guess.
Thank you. Any further, well, first of all, Mr. Cohen, any comments?
No, thank you. Thanks to Representative Reckitt for putting in both of those bills.
All right. Representative Reckitt, did you have another question or are you all set? Okay. Does any other member of the committee have a question? Looks like we're all set. Thank you very much, Mr. Cohen. We appreciate you being here this afternoon.
Thank you very much. Have a great rest of your day.
And now we'll move on to our second to last presenter. It is the Maine Roadways and Maine Alliance for Road Associations. Roberta Manter, welcome this afternoon to the Judiciary Committee.
Thank you for having me. I'm going to try to cram two organizations into one time slot here, so hopefully I can manage that without making it too rushed. First of all, there is some overlap between the two organizations. The Maine Alliance for Road Associations works with private roads that are not maintained by the public, and Maine Roadways, which is an acronym for Residents and Owners on Abandoned and Discontinued Ways. We work with roads that have been abandoned or discontinued and therefore also are not maintained by the public. The big difference between them is that private roads are just what it sounds like. They're private. They're not for general public use, and they're generally dead ends. They're mostly subdivision roads. So the owners of the subdivision or the members of the road association have control over the road. Whereas roads that have been abandoned or discontinued, depending on the date on which that occurred, they often are retained as public easements. And a public easement is a road which remains open to general public use at any time of day, any time of the year, no matter what the condition of the road is. And the abutters on that road have no say over who can use the road or when, but the public doesn't pay to maintain it. And this runs into some problems, particularly when it comes to trying to form a road association, because how can you force private individuals to maintain a public road at private expense? That would be unconstitutional. So where Mara can set up road associations to maintain these roads, that's rather difficult for people in main roadways. Just to give you a little bit of history about the two organizations, back in 2007, the legislature did a major revision of the statutes regarding road associations, which is Title 23, Section 3101 through 3106. And it became apparent that people were going to need a little bit of assistance figuring out how to apply these laws, how to set up a road association, how to run a road association. So our founder, Betsy Bowen, stepped forward and started MARA, the Maine Alliance for Road Associations. MARA over the years has had, well, let's see, we're closing in now on 500 members past and present. We currently have, I believe, 110 active members representing nearly 100 different road associations. And of course, each of those road associations represents a number of people. So it's a pretty comprehensive organization when it comes to representing road associations. We had a conference, we have a conference each year. This year, because of COVID, we had it a combination of in-person with social distancing and Zoom. And that allowed us to accommodate, I believe, 43 participants who were each then able to take what they learned back to their road associations. Our speakers were attorneys Mary Dennison and John Cunningham, who are probably the two best in the state when it comes to road law, and John McLean, who is the non-point source pollution coordinator for the DEP. So we had some really excellent speakers, and the conference was very well received. Mara also has a website. It's and my mind has gone blank now on what the website is. Anyway, I can get back to that later. But on the website, we feature a number of resources for people setting up road associations. There are sample forums. There's a manual on running road associations. There are links to manuals on gravel road maintenance. There's a forum which allows people, it's a searchable forum. It allows members to post questions and reply to them. We have a good discussion that goes on there on a number of topics. People who are not members can still look at the forum, they just can't, they can't join in the conversation. But being a searchable forum, they're able to go on and get a lot of information that's helpful to road associations. Questions include things like how to start a road association, how to run meetings, what to do about road maintenance issues, how to determine how much they should be charging for dues, what to do when someone damages the road, what to do about ATVs abusing the road. All kinds of questions come up on the forum. And usually either the other members or the board members are able to answer those questions. We also have a agreement with those same two attorneys that if we come to a really thorny question, we can refer it to them. And if it's a question of general interest, they will give us an answer that we can post on the forum. Let's see. We also have an annual newsletter called Mud Season that goes out in the spring. We also send out emails when there are things of general interest to the membership, legislative hearings coming up and that sort of thing, conferences. And we do represent the road associations at these legislative hearings. Moving on to main roadways, Main roadways began because in 1971, my husband bought a piece of land that said it was on a discontinued road. He thought this was going to be a nice secluded place for him to retreat to. He had not at the time been diagnosed, but later found out he had PTSD. And so he just kind of wanted to get away from the world. But he no sooner rebuilt the road so that he could get to the place than loggers started using it and absolutely destroyed the road. And that led to one thing and another, finally went through 2 lawsuits. And at the end of it, we ended up with a decision from the Maine Supreme Court saying that, yes, it's a public road and no, the public doesn't have to maintain it, which made no sense to us. And it took us years to figure out exactly what had gone wrong, what we could have claimed that might have stopped that from happening, et cetera. And over the years, we found that there were a lot of other people who were in the same boat. The decision came down in 1984, and it wasn't long after that that we began sort of collecting other people that we learned were having similar problems. And we decided that the only way we were going to change the legislation and get something that made more sense would be if we could all band together. At first, it was just the 2 of us, my husband and me, coming to legislative hearings. And the legislature kind of said, oh, well, that's just a matter, so why bother? So we began documenting how many we could find. And if I can bring it up here, I think I can put this in the background for a minute. We keep a map now with a pin in each town. This is only 1 pin per town where we've identified a problem road. And many towns have more than 1 problem road. The blue pins are just problem roads that we've heard about either through word of mouth, people contacting us, news items, etc. The pink pins are problems that were so bad they made it to Superior Court. The red pins are ones that were so bad they ended up getting appealed to the Maine Supreme Court. And that doesn't necessarily mean that the situation was satisfactorily resolved. It could mean that the people just ran out of money to fight it. So Maine Roadways has both a website, which is mainroadways.blogspot.com. We also have a Facebook page, and people can contact us through either one for assistance. We help people research the status of their road. We help them find where the laws are that apply. Since I'm not an attorney, I can't interpret law or give legal advice, but we can tell them what we've been through, and they can just learn from our experience and from the experience of other people that we've been in contact with, and take that or leave it for whatever it's worth. Recently, I took a course in mediation with the hope that some of the skills I learned there will help me to defuse some of the situations we run across. Some of the disputes between landowners and towns can get very heated. There are situations where one person thought they owned the whole road, and then someone else says, but I need access to my property. And there can get to be some real Hatfield and McCoy type feuds over these things. So we try to be a voice of reason, try to find solutions that work for everybody. And that's what we've been working for in the legislation too, is to try to get solutions that help all the parties involved, and it's something that they can all live with. Let's see.
I'm just wanted to check in with you. We have about 2 minutes left. Do you want to open it up for questions, or do you have additional material?
I'll just say real quickly, the pins on the map, we have about 250 towns, about 570 roads, 59 Superior Court cases, 75 Supreme Court cases. And according to the DOT, there are somewhere around 3,000 discontinued roads. That only counts the ones that were discontinued by counties, not the ones that were discontinued by towns. So I'd be happy to try to answer any questions you have.
Thank you. That's a wealth of information. And I'll just look to the committee members. Does anybody have any questions? You can try to use the raise hand function or wave your hand if your raise hand function doesn't work. So I am not seeing any questions. Representative Babbage?
Sorry to interrupt the efficiency here, but just what's discontinued road, Ms. Manter?
Okay, a discontinued road is one that either the town or the county has gone through a process. It's for towns, it's regulated under Title 23, Section 3026A. There's a process where they have to notify the abutting landowners. We got an amendment to that law just a few years ago saying that they have to give the landowners a year in which to see if they can negotiate shared private easements so that the public easement can be given up. Before that, from 1965 until that amendment was passed, the procedure automatically retained a public easement over the road. And that was to assure that nobody would get landlocked. But the problem with it is that because you're keeping it as a public easement, the general public can use it and wear it out, and they have no particular interest in what they leave behind them. So people that do not depend on the road for access can tear up all the work that the abutters have put into it, trying to make it passable. So it can end up, even though legally they have access, physically they don't have access.
So just to clarify, is the public easement discontinued, or is it a financial responsibility that's discontinued?
Basically, it's the maintenance that's discontinued. Okay. The town has no further liability for the condition of the road, and they have no further obligation to do any maintenance on the road. So the people on the road pay taxes and get nothing in return. We call it mining taxes. They take our taxes and put it into a road on the other side of town someplace, and we don't get a penny of it back.
Okay, thanks very much. Appreciate it.
Yeah.
All right, thank you, Representative Babbage, and Ms. Manter, thank you so much for your presentation this afternoon. I would like to give Senator Sanborn a chance to introduce herself. She's just joined us.
Thanks, Senator Carney. I'm Heather Sanborn. I represent District 28, which is half of Portland and half of Westbrook, and just wrapped up my other committee's business for the day a short time ago. So I'm glad to catch a little bit of the orientation today.
Thank you for joining us. We have, I think our final group is ready. It's the Maine Prisoner Advocacy Coalition with Jan Collins and Mr. Jackson, are you also here on that topic?
I am.
Great. Welcome to you both. Before we turn to your presentation, Steve Gordon had a technical glitch when it was his turn to present and somebody presented on his behalf, but he probably would just like to say hello to us. So go ahead, Mr. Gordon. Oh, he still can't. Okay. I think he'll just listen in. So welcome very much, Mr. Jackson and Ms. Collins. The floor is yours.
Well, thank you for letting us come here today. My name is Joseph Jackson. I'm the Executive Director with Maine Prisoner Advocacy Coalition.
And I'm Jan Collins. I'm the Assistant Director of Maine Prisoner Advocacy Coalition.
And just to give you a background about Maine Prisoner Advocacy Coalition, we were founded in 2007 as Mainers Against Solitary Confinement. Today, our mission is to support Maine's incarcerated citizens, their families and friends in the struggle with the Maine criminal justice system. And our purpose is to reduce Maine's use of incarceration by creating a justice system that is ethical, humane, and restorative in nature. And just a little bit, we are in coalition with many other organizations throughout the state, whom you will know, at least 30 organizations. And our social platform has over 500 folks that follow us regularly for information sharing. I don't know if Jan's frozen.
No, I'm here. Many of our major concerns parallel those in the 2019 Justice Reinvestment Report, which most of the committee here is very familiar with. It is a blueprint for change in Maine's criminal justice system, and some of the areas for which we are most concerned are we'll mention next.
Yeah, I think one of the parts is that we feel that Maine jails and prisons are filled with people who could be better served in a medical setting. And to put that in a little bit broader context, Maine seems to be criminalizing mental health. So we find people with a lot of mental health issues find themselves incarcerated, whether that's substance use, which is also a diagnosis. And then lastly, compassionate people that are at the end of their lives. And so thinking about, could there be other mechanisms that we could use for accountability?
So just emphasizing what Joseph said about mental health, we know that when we had the consent decree for AmHigh, that emptied about 1,200 people into our communities without the kind of support necessary for them to be successful. That continues to haunt us today. The rise in the number of people who are in our jails and prisons is almost equal to the number of people who were sent to the communities to care for during the consent decree. You heard 2 days ago from the Department of Corrections, which was great. They're one of our partners. But one of our big concerns is the Long Creek Juvenile Corrections Center. We feel strongly that it does not well serve our communities or our youth. And it is the money that is spent there could be much better spent in community services for our youth who most need it. Currently, the budget for Long Creek is $12 million, and they serve approximately 30 or less children. So that's a huge amount of money per person that we think would be better spent in our communities caring for the youth in a family setting.
And just to add on a little bit to that, we also sat on the Juvenile Justice Advisory Group regarding young people for the task force, recognizing that many of the young people, at least 1/3, were coming directly through residential settings for mental health and right into incarcerated setting. And then the last part is that 44% of young people who are being released return within the first year. So we definitely feel that with that kind of record that we need to really look at some other measures dealing with our young people. And part of that really is about the Maine Public Defender's Office. We feel that right now it is understaffed. And it's definitely that understaffing leads to inadequate representation, particularly for people who are poor and from the lower social classes.
A huge burden for the poor. And again, we have almost a two-tiered system of criminal justice in Maine, one for people who can afford to have an attorney and one for those who cannot. One of the issues, huge issues, is the cash bail system that we currently have, which is an insurmountable hurdle for most poor Mainers. As a result, they may be in jail, lose their job, which would be their only way of paying for their bail, lose their community supports, lose their access to the healthcare that would have served them out in the community, and oftentimes lose access to their families. So everything is lost once they enter the system, and they have no way of fighting that, no way of getting the money they need for bail that would allow them to continue in the community and not lose everything they own and all the people they know.
And just for a little bit of context, right now, currently, Maine has like a $500 personal recognizant bail that is and now it seems that number is being bumped up to $2,500. So we've seen a lot more $2,500 bails versus a $500 bail. So I really want to understand the severe impact it's having on folks from lower socioeconomic classes. And then the other area we're looking at is like really programming in jail, understanding that the Department of Corrections came and said that programming was still occurring within facilities. I would add that it's limited. And so much of the programming and rehabilitative programming that happens within incarceration settings has been discontinued and shut off due to the pandemic, for the most part, because a lot of volunteers are used to to hold that programming, whether that programming is around addiction, or that programming is around anger management, or even reentry. It is really difficult, for those folks to be to access that programming when they're being virtually locked in their particular dorms and pods. And there's no intermingling amongst the population currently.
So this lack of services, and even in the best of times, if you were to go to any prison in the state of Maine, you would find that most of the people, probably about 75% of the people, have no programming. They are in their cells, they watch television, they play cards. None of this is leading to any kind of success with reentry when they leave the facility.
Thank you.
So those leaving have no financial resources, no skills, no more ability to function socially than they did when they came in. And that leads to a cycle of despair for everyone involved.
And just a little bit of context. I know that we have very little time. A lot of folks that we're recognizing that is being released right now are being released homeless, and with very little resources. $50 a gate money is not going to cover rent. They have access to employment. All of these things are being impacted.
And as Representative Evangelist will tell us and has put forth a bill for us, there is no parole in Maine. Parole is an incentive program where if you are doing your best to improve yourself, to get skills, to get education, to learn how to be more socially facile, then you are going to get a reward. You're no longer a threat to anybody in the community or the society. You should be able to be rewarded for all that hard work, but currently you don't. If you do all that work, it's not going to get you out any sooner than you would have if you did nothing.
And all I would add to that, I think it really it fails to recognize that change is a law of life, that people are not stuck in a particular place, a period of time, or around a particular act, and that folks can grow, and that our current policy has no recognition of that growth. And I'll let you handle this one, Jan. It's your baby.
Thanks. What we have seen as far as crime in Maine is that crime is down, that arrests are down, and yet our prison population, with the exception of this year of COVID, when the criminal justice system is basically on hold, we have seen increases across the same time period where we're seeing a decrease in crime, we're seeing an increase in the number of people who are incarcerated. Part of that is because we have longer sentences than we had in the past. As a result of that, we have people who are in prison, who have dementia, who are dying from old age or from disease that they have accumulated as a result of living in a very stressful situation. These people are no longer a threat to their communities. They are not receiving the services that they would if they were out in the community. And they're using a lot of the money that we have put into corrections to keep people who are a threat to community from threatening the community. We feel very strongly that the department should use the policy that they have in place to release people for compassionate care in the community, still under DOC's oversight, and be allowed to die in the community where they can say goodbye to the people that they love.
Yeah, just two couple of last points. COVID-19 remains to be a ticking time bomb. We have no plan about vaccinations. There is no cohort for staffing. And then I just want to, because I wanted to leave time for us to question. They just recognize that our justice system, according, not only have to look at this justice reinvestment report, but it's definitely impacting different parts of our population differently, and particularly when it comes to race. And I think that and I think that there are plenty of ample evidence out there that supports this, and we've included it in that package. But I definitely want to leave time for folks to have questions for us if they have them.
Thank you very much for presenting that important information. Would you, let's see, are you ready for questions now, both of you?
Most definitely.
Okay, great. Do committee members have questions? Representative Evangelos and then Representative Libby.
Thank you, Madam Chair. And I want to thank both of you for appearing here today. You both know more than all of us about the difficult circumstances we're facing. And Joseph, you're absolutely right. The pathway to redemption is blocked at every juncture. I just wanted to make sure, I sent an email out to my chairs this morning. I wanted to ascertain whether you and Joseph and Jan received it.
Most
Yes.
definitely. Yeah.
And once I hear back from the chairs, would you be willing to help facilitate the progress on that?
Absolutely.
We'd be glad to.
Okay, just so the people on the committee know, I did make a request this morning of the committee chairs of Criminal Justice and Judiciary that now that we're doing this Zoom business, I would like to have a 4-hour hearing whereby the Criminal Justice and Judiciary Committee holds a joint hearing, and we will hear from the prisoners at the Maine State Prison, the Bolduc unit, and the women's facility, and allow them to tell us their stories and their struggles. A, to turn their lives around, but B, the impediments that are put in front of them that Mr. Jackson just mentioned. Quite frankly, if you're in prison for 20 or 30 years and you go to college and get your bachelor's degree and your master's degree and you never get in trouble, you're going to get out the same day as someone who has done nothing and who has been in trouble. And that's just not acceptable. And I look forward to continuing this conversation, and I hope to hear from my chairs, and we'll get back to you. Thank you very much.
Thank you, Representative Evangelos. I did see that you sent me an email, but I've been in meetings since early this morning, so I haven't had a chance to read it. But I appreciate your comments. Representative Libby.
Thank you, Madam Chair. Thank you both for such a thorough presentation. I have a few questions, and so if you're unable to get to answering all of them, you can send me the information. That would be much appreciated. So I'll start with ones that I think will be quick. First, I'm interested in hearing more about compassionate release for the dying and what that looks like or would look like with a mechanism for release to hospice, or your thoughts on the issue. Second, related to number 6, Maine having no parole. I would love to see studies or what that has looked like in other states with rates of recidivism in states that do have parole. And thirdly, and maybe this is the biggest question, is number 2 with juvenile corrections. My question is, I'd love to hear you highlight what your the goals are that you're advocating for in this area. And thank you very much. I realize those are 3 very different questions.
Jan, you want to tackle the first one about compassionate release?
So that's the easy one because we have a bill we have a bill. So you'll have all the details as soon as that bill comes out of comes out with an LD.
Out of the
So,
revisor's office.
Thank
And
you, the
that's-
revisor's office. I always, that name never works for me, so I forget it all the time. Yes, but after it comes out of the revisor's office, you'll have all the details, and that's probably the best time to talk more about that. But I have your email, Senator Libby, and I would be glad to send you what we have for a summary on that bill.
And addressing that issue in the context of a bill that's before our committee is a great way for us to do a deep dive into it. So thank you.
And I guess, but while I can't, cite information about parole off the top of my head. I will say this: Representative Evangelos made a great point about education, and as we begin to look at education and the role that education plays with recidivism, we start looking at a VA that the number drops down to 9% recidivism rate, and then when you look at anything higher than that, it drops way down. So there's plenty ample of resources around that if you're attaching parole to rehabilitative programming and people seeking to improve themselves. Muskie has some studies on that. And then lastly, I think with juvenile corrections, I mean, we're looking at a budget right now that's, pretty steep for a facility that's holding, around 30 young people. I think what we would like to see happen and what we've seen in other states is young people being moved into the communities and under different programming that have been what's the word? I want to say research-based programming, and there are a lot of research-based programming that other states have done to almost just virtually eliminate our need for a facility like Long Creek. With the juvenile task force, I think when we were going through that, we saw that we only had around like a handful of young people who had committed really serious crimes. So definitely there has to be something done with that, but that's a far cry from 30 and the 200 size bed unit.
Thank you very much. Representative Libby, are you all set? I'm losing you on the screen. There you are. You went diagonal on me. Thank you. Let's see, Steve Gordon, thank you very much for hanging in there with us. Would you like to speak?
Yeah, I'd like to add to this, and I think Jan and I participated in one discussion together. I represent counties, which is the jails. And what we're beginning to realize that jails are becoming the public service of last resort. And I'll dovetail this right into what they're talking about, which I think is very, very good. When the community or anybody in the community is detained or picked up or whatever, and you don't know where to take them, they go to jail. And somewhere along the line, we've got to develop, or we should in the future, we should develop some process before when a person gets detained, before they get arrested, if there's an issue in there that people recognize, that they don't go into the judicial system, because you see the recidivism all the time of these people that go round and round and round because they don't know what to do with them. They take them to jail. The district attorney gets them, time served, back out. And we need another way to do this. Let me reinforce some of the things that Jan said. Do you realize that over 75% of the people incarcerated in jails, not the prisons, I don't know the factors in the prisons, but in the jails, are on some sort of psychotropic drug daily? To me, that's just the public should give recognition that that's a mental health illness. And so, you think of the things that people are there for, and why would you take them to jail? If somebody's got a mental illness, would you take them to jail for treatment? If somebody's got substance addiction, would you take them to jail for their treatment? If they're homeless, would you take them to jail for their treatment? If they're part of human trafficking, would you take them to jail for their consideration? Education of human sexuality, would you take them to jail? No, but that's what jails are becoming. There's this long transitional paradigm that's growing because people don't know what to do with those that they don't understand or they don't appreciate, and so they go to jail. Jan, thank you, and Joseph, thank you for what you. I didn't know that you were existing and doing this, so serendipitously, I've entered into this conversation, and I really appreciate it. And thank you, Senator. I appreciate the time.
No, I think that it worked out beautifully that you had those technical glitches were meant to be and really enriched our conversation this afternoon. Does any committee member or any of our guests have final comments or remarks that they'd like to make? Okay, first committee members. Go ahead, Representative Babbage.
Thank you. I've forgotten how to raise my hand here. I hit participants in chat and all that, and I'm not able to do it in the manner that I'm supposed to, Madam Chair, so I apologize. But I did want to I did want to say, and I appreciate all these comments, and I don't know if Mr. Jackson or Ms. Collins has a website or email that we might be able to contact them if we had a question. But you know, I've had the opportunity to visit what was the Boys Training Center, 2 generations ago, and the Maine State Prison, the old one in Thomaston, and I'm just thinking that my knowledge of these facilities is very, very dated, and I wasn't in the position I am now in order to be able to react to that. But if criminal justice is doing any tours, which committees often do, if it weren't on a committee meeting day for us, I would love to be in the position to be able to visit some of these facilities and get a better understanding of them. So I just wanted to put that out there.
Thank you very much, Representative Babbage. Any final remarks from any of our guests?
Yeah, I would just add that one of the things I probably should have added in my title is I'm also a returning citizen. So I did time at the old facility in Thomaston, and in the new facilities and the majority of facilities around the state. And just wanted to say that thank you all for taking the time to listen. Jail is a very place where there's a lot of trauma. I think everyone who enters the facilities are traumatized, whether they're staff or individuals, and that we need to figure out a way for it to transform this trauma into a place of restoration and healing, where we can really, live up to our values of whatever we want to call rehabilitation, but definitely restoration of individuals. 95% return. That's what we have to remember, that 95% of the people we incarcerate return to our communities. And then how do we want them to return? And right now, we're not doing a very good job.
Thank you. That was a really powerful point to conclude on. And I will, I think we're done here. Is everybody, Jan, would you like a final thought?
No, thank you so much to everybody who is here today. And thank you to Steve. Steve, we are right on the same page. That's, I think it's time. So thank you so much. And I hope we have lots more conversations in the future. Please feel free. I left my email in the chat. Anybody who would like to contact me, I would love to hear from you.
Yeah, thank you all to all of our participants today and to everyone who spoke earlier. This was a wealth of knowledge and really important information for us to all think about in the days to come. Thank you very much. And at this point, the orientation presentations are completed, and committee members, I think that our meeting is done for the day. Do we have a motion to adjourn? I'm not seeing everybody, so.
Madam Chair, can you hear me?
Yes, I can. Thank you.
I lost my screen.
Yeah.
Is the meeting going to be over when we adjourn, or are we going to have a discussion or some questions amongst the committee members? It was on the agenda.
Madam
Okay.
Chair, this is Soupy. Chris needs to stop screen sharing. That's the problem.
Yeah, Representative Babbage, do you know how to stop screen sharing? And if not, could you log off and then log back on, please?
There we go.
There.
Thank you.
All right. We're all still here. That's great. Okay, thank you very much to our guests. And now discussion among committee members.
May I continue then?
You may continue. And also, I just want to let people know that we have the matter of voting on our committee rules as well.
Okay, I'll be very brief, but I'm really concerned about our workload, and that we've got Wednesdays available and we're starting at noon and all of that. Especially concerned about the judicial confirmation hearings. How many of those are we going to do in a day? Does anybody know?
Yeah, I can answer that, and I can provide you all of the committee members with some additional information. So the judicial confirmations, because there are so many of them, and we are working very hard to forward any that we approve to the Senate so that we can help the judiciary meet the anticipated influx of cases that will be tried once the pandemic is over. We have decided to do the start the confirmation hearings at 9 o'clock in the morning on Tuesday, the 9th of February, and Tuesday, February 16th. And those will go probably from 9 to 5, both of those days. As we are also, because as you mentioned, the crush of work that our committee has, that we are going to soon start our meetings at 10 o'clock in the morning. There are a couple of members who can't always be with us in the morning, and we're working to accommodate them by making sure that we schedule work sessions when we vote on bills for the afternoon so that they're able to weigh in on the work sessions. But as far as public hearings go, we're going to start meeting at 10 o'clock in the morning for the public hearings. That's not in place for this week. That will be in place starting on February 11th, which is a Thursday.
So on the judicial hearings, how many a day are we going to be attempting to do?
The schedule calls for 5 hearings a day. Not all of them are judicial confirmations. Each day we have 4 judicial confirmations. And then on the 9th, we have the MITSIC appointment and a Maine Human Rights Commission appointment on the 16th.
So on just addressing the judicial confirmation hearings in the time allotted, and I hold myself as equally responsible as any other member of the committee in the past, but we need to do better. Half the time the questionnaires aren't even filled out. I'm going to need a stack of paper forms that the judicial nominees fill out so I can take them home, take my notes. I'm not having any success when I try to leave the Zoom and go onto another screen. So I'm running 2 computers so I can do that. But it's very important that we do our due diligence. These people are facing 7-year appointments, and part of their job responsibility is to, quite frankly, put people in cages. And I'm going to do my job this time. I'm going to do my due diligence, and 1 hour may not be enough if there's some history of these judicial nominees. We need to ask the tough questions, and in all due respect, and I don't want to create a fur fight over this, but the Democrats spent three days on Kavanaugh down in Washington, and we get an hour to talk. It's not adequate.
Okay, well, we will take the time that we need for those hearings.
Okay, can we have our paper files a week in advance so we can do our due diligence, so we can study?
We are working on that. Representative Harnett, my co-chair, wants to weigh in on this. Go ahead, Tom.
Thank you, Madam Chair. A couple of things, and I don't know if anyone else has experienced this, but my screen is totally changed and distorted. People's faces don't match up with the names, and everything's changed in the last couple of minutes. But I thought, I understand Representative Evangelos's concern, and it is a very important job that we have when we are doing judicial confirmations. I would point out that many of these are reconfirmations or second or third confirmations, and we have requested production of the materials prior to the meeting. That is a concern, to receive them the day of the meeting, the day of the hearing. And it's also a concern to receive forms that have not been completed. And I felt after one of our earlier meetings that there was an assurance given that we will have those in advance of the public hearing day, with at least 48 hours. And I would hope it could be even longer than that, more time than that.
That was my understanding as well, and I'm hopeful that we'll get them the Friday before the Tuesday hearing. We are working on that, Representative Evangelos. Let's see, Representative Babbage.
Yes, thank you.
Oh, I'm sorry, Chris, I'm going to ask you to hold off because
Sure.
Representative Hagan had his hand up and I'm
still trying to do that.
Okay, go
Thanks,
ahead.
Heather, though, for trying to help me.
I will be very quick. I just wanted to say that I appreciate that from Representative Evangelos and Representative Harnett. I too would really like to have all of the information, the forms filled out completely, with plenty of time to go into it so that I can do my due diligence and research. And, so I would throw my hat in the ring in support of that. Thank you.
Yeah, thank you. Representative Babbage.
Yes, thank you. Thank you, Madam Chair. I guess this is a time for me to share with the committee that I don't know how long ago it was, 10 days or seems like several months, so much has happened. But I shared with the two chairs my concern about this issue. And actually, I'm not trying to make this an issue like Washington, which has become politicized with appointments. But I do want to feel better about the process by which we approve these people in a judiciary in which there's a great deal of trust once a person gets their position. So there's a little bit of a fiefdom, that is established, and so we're one of the few hurdles to establish that, and so I have been part of a different committee which did refuse actually what we ended up doing. It was a delay of an appointment, but that delay caused statewide press coverage and tumult with regard to the principles involved. And my point about all of this, if we can do due diligence, if the timetable is such that we get information that we can digest, and if we have questions, we can go to the governor's office or we can go to the nominee and settle some of the big issues prior to the point when the nominee is there with their family. All of these vettings come in and say everything's fine, and we're required to open up perhaps a high level discussion on an important issue at the 11th hour. That is I realize, it doesn't have to be that way if we can familiarize ourselves with the information and have the opportunity to find some answers, or at least a lead-in to facilitate a final chapter in the nomination process. So my thought process was, regarding this judicial nominee process, should we establish, if not for these judicial nominees that are coming, should we establish a process, is that we're going to be our task here, by which we can do, as Jeff says, our due diligence. And because I look at I look at my history on this committee, and I can think of 2 or 3 people by which we affirmed them, and I felt that had we had more time to interrogate and find answers, we'd just be able to sleep better at night regarding these. And that's not to say I'm not going to mention names, of course, because my concerns may be unwarranted, but there should be time to address that prior to something that's brought up at a hearing at the 11th hour. So I know that there's going to be pushback on this, because right now it really is vetted by people, and I'm not sure anybody wants us to take a bigger role than we've taken in the past, but we do have an obligation, and so I'm supportive of this discussion. Thanks so much.
Well, thank you for sharing your thoughts. And I think that we do, certainly we do want to get the material sufficiently in advance of the hearings, as we have all requested. Representative Moriarty, would you like to speak? You're muted, Steve.
Thanks. I wanted to remind folks that on initial appointments, there is already substantial screening and vetting that takes place before it hits our schedule. We learned 2 days ago that an applicant applies online, and then they're sort of winnowing down until the governor finally makes, upon the advice and recommendation of the Judicial Nomination Committee, makes a choice, and then that person comes to us with whatever paperwork may be available. On a renomination situation, in addition to that sort of input, we also had input from the Maine Bar, and we heard about their process in terms of obtaining information from practicing attorneys on their experience with a particular judge whose nomination or renomination is before us. So in either case, these people are not coming to us cold, so to speak. They have already gone through a fair amount of analysis and interviewing, and I don't think we need to take the position that we need to start at square one. Rather, we take over from those who have vetted before us on a particular nominee and determine whether or not there are any issues that need to be pursued any further. And I'll just share my personal experience on judiciary in the 126th from 2012 to 2014. That was during the LePage administration. He had an outstanding judicial selection committee, and in my judgment, he sent us an extraordinary group of nominees for the district and superior courts. And I assume that they have since been, most of them have since been reappointed to second terms, as more than 7 years has passed. So I wouldn't downplay the role that the governors, any governor's nomination committee plays. It's substantial.
Thank you, Steve. And I just also want to mention that we heard today from the Maine Trial Lawyers Association that they also have a questionnaire and vet judicial nominees and pass that information along to us as well. I want to ask, I know that Chris, you also raised a question about process. And I know that there is a process that we are required to follow as far as our hearing. And I'd like our analysts maybe to, if they're able to weigh in on that after Representative Reckitt provides her feedback. Go ahead, Wallace.
Well, I think I have a kind of a unique perspective on this question. And let me tell you why. I mean, I started paying attention to judicial appointments and reappointments, particularly when I was working in my job in my other life. And part of the problem is that we in the domestic violence network, and I can only speak about that venue, we had a lot of interaction, watching or interacting ourselves with judges. And occasionally we were disturbed by that. And the problem was that no one who was in the legal community, who was a lawyer or a judge, God forbid, wanted to open their mouths and say anything because it felt dangerous to them. That's both private practice attorneys and those who worked within the system, even in the nonprofit system. So Sally Brave One here stepped into the void. And I did that because I believed that people who watched the courts in action, who may not have had personal stakes in them, but who were observing them with a perspective that was not necessarily the perspective of the law, but the perspective of, I always say, you know, sometimes I will want to do something and people say, well, that's not legal. And I would say, well, then which law is it not legal with? And if it's an important enough thing, let's change the law, you know, because I think there's a difference between what's legal and what's right sometimes. And I think that in this whole process, I think we have to have a perspective that is broader than the legal community, although informed by the law and the legal community. I'm not saying that's irrelevant. It's absolutely relevant. But I think there's another piece that often gets left off. And so I have frequently in my career been the voice of the piece that got left off. And sometimes I won and sometimes I lost. But most of the time that I was most effective was intervening somewhere along in the process before it got to the Judiciary Committee. But I have also testified both in favor and in opposition to judges before this committee when I wasn't a member of the legislature. And let me tell you, it is intimidating. I can recollect one time that I testified, and I swear to God, if the judge could have seen me, looked at me, I'd have been killed with the poison from the eyes, you know? I mean, it was a very scary thing for me. And yet my livelihood didn't depend on it. So I think we can't expect the legal profession to always, particularly in small jurisdictions, as we heard the other day, where it might be easy to figure out where this feedback's coming from, because there's only 4 lawyers in the county, or, you know, whatever. I don't know what the piece was. I, of course, was working in the largest court, so it was fine to be anonymous, but my perspective made it clear that it was the domestic violence system that I thought there was a problem. And it was not so much the law, it was how defendants were treated, or plaintiffs or defendants were treated inside the court. That was always my major beef. And I think that it was important that that kind of voice had time to figure out what was going on. And the first step in that is for us to get our information early enough. I'm not sure that's the solution to the problem, but it's at least a step. Check.
Thank you. Thank you. I will just make one quick observation on the attorney questionnaires that I've completed countless questionnaires, and the process to me as an attorney did seem safe and anonymous, and I felt very comfortable sharing some very pointed criticism of some judges, as well as high praise of judges. So I don't think we can necessarily assume that the process is tainted. That certainly was not my experience from the evaluators end. Representative Libby, you have the floor.
Thank you, Madam Chair. I guess I have a couple questions as I am new to the committee and this process included in what I have to say. So I guess one question is, what exactly is included in the information that we get prior to the hearings? From what we heard yesterday, I guess I have some confusion on that issue. To me, it seems that if we're not privy to all the information that the folks have that are handing off to us, then it would seem that we would need more information, more time to do our due diligence. If we have all the information that the folks handing off to us have, then you know, maybe that's a moot point. But it sounded to me like we're not privy to all of the questionnaires and information that those handing off to us have. And I'd like to have a more full picture of that. If the information is to be available the Friday before the 9th, is there any reason that the hearings can't be delayed a week so that we have time to do that due diligence?
On the issue of the process, we're going to ask our analysts to weigh in. And one of the concerns about delaying it is that we are just the beginning step of the process. And we're looking at for any nominee who is approved by the committee would go before the Senate for a confirmation vote in March, so that the judiciary can be in full strength when they need to be as we emerge from the pandemic. But let's turn things over to the analysts at this point, and they can give us all more information about the process. Thank you.
Hi, I think Sam and I are going to try to double team you here. Analysts aren't typically involved in confirmations just because that's kind of a political activity that the legislature engages in. Can you hear me okay?
Yeah, we hear you just fine.
And so there are a couple of things that govern confirmations. One, Sam, if you can click on that confirmation tab, is the joint rules. And so the joint rules provide for partisan staff assistance for nominations. And in that rule 501, the partisan staff assistance for nominations shall provide all necessary assistance to each joint standing committee required by law to recommend action on a gubernatorial nominee. In the past, that used to be a very active thing that the various offices did, and they did a lot of information gathering, and they worked for the members of the committee. I think that has just fallen away mainly because there hasn't been as much controversy about nominations. But that is in the joint rules for the partisan offices to help. So to the extent that you need copies of materials, that might be the best way to go through. Supi might want to explain to you what she receives for files. Generally, I mean, we're doing confirmations a little bit differently this year, so I'm not sure if all of that is still going through Supi or not. The other thing, which I don't believe it's ever happened. Sam, could you switch to Title III, Section 156? So I mean, I don't know how much history you want here. At one point, a legislative committee tried to use the executive sessions section of the Freedom of Access Act to hold an executive session on a confirmation of I believe it was a commissioner. And the Attorney General's office said, well, you can't really do that because the commissioner is not your employee. If you were talking about hiring or disciplining your own employee, you can use an executive session, but that's not what a commissioner is. That's not the relationship between a commissioner and a committee. So they established this whole chapter 6. It's posted on the orientation materials. It's in your folder that we sent you that I hope everybody got by now. But one of the things that they wrote into the statute there that I don't think has ever been used since 1993 or 1994 is that a committee, if you have concerns, you can actually schedule a it's called a pre-hearing conference, and it can be closed to the public. I think you have to, I mean, I know it says the committee shall hold it unless they decide not to. No committee has ever held one of these that I know of. But if you really do have concerns about a particular nominee, and I think one of you was concerned about this, about raising these questions in a public forum, that this is an option. However, this option has to be scheduled before the public hearing. One of the things about not postponing, I mean, you could postpone a public hearing. The statute in earlier on, it might be like 153, provides that there has to be 7 days notice in a newspaper of general circulation before the hearing. So once you schedule it, we actually try to stick with it. If the committee decides they need more time, and I mean, that's something you're going to have to discuss, you would have to cancel the hearing, which means you'd have to go through the presiding officers to authorize that cancellation. There is a certain amount of time before the committee has to vote and the Senate has to vote. So all those things are laid out in statute, how you do it. And I guess that's the information I can share about the procedure. I don't know if Soupy has some more things to say. I'm happy to answer any questions.
Thank you very much. Before we, Soupy, did you have anything that you wanted to contribute before we see if folks have questions?
Not really. Everything is so different this year, and I am forwarding as soon as I get it. They've been very slow about sending me anything this year. So really, I haven't forwarded anything to you because there really hasn't been anything to forward. So I apologize for that. I'm not supposed to be making files for you. I'm making files for myself because that's the only way I can keep organized. So I really don't have a lot to add.
Okay, so do any committee members have questions about process that we could put to our analysts?
I guess so.
Go ahead, Chris.
Thank you. I guess I'm open. Yeah, Peggy, I am actually, I should have remembered, but I didn't know about partisan staff being so involved in the past. And I'm wondering if that's before FOA, as far as a pre-hearing conference being an executive session. I just want to explain, my interest is not to make this a partisan Washington-like process. My concern is that this committee does not get the proper respect to get information 2 weeks prior to a hearing, whereby if the information isn't sufficient, we have the opportunity to follow up with a request for information prior to a public hearing that allows us to do this efficiently, satisfy our need for due diligence and avoid unnecessary 11th hour wrenches into the process and to the timing demands by bringing it up at the last minute. Now, I realize at a public hearing, the public can come in and say, this guy convicted me 10 years ago and he was unfair. I mean, I realize that's possible. But generally speaking, I'm thinking about the efficiency of the process. Oftentimes we get information very late, and I know it isn't at all anything to do with our staff getting it to us. They're wonderful. But, and sometimes the information is dated and incomplete. And at least I consider it so, to have a handle on the nominee. And that's what, so what I'm looking for really there's no motivation for anybody to give this information early unless we demand it early. Because if they can give it to us the 11th hour and then, the hearing's the next day, why not? But but if there's a statute or a rule that we apply for or whatever, that we must have it by a certain time, then I think that's respectful to our role in the process. And I don't have any issue at all with what Representative Moriarty said. I mean, both governors, both chief executives have had great committees, and I think put forward nominees who are bipartisan most of the time, and but that doesn't mean that they're okay.
Let me just ask a clarifying question. So we've received assurances that we would get the information at least 48 hours in advance, and that is what Representative Harnett and I are expecting to happen? Are there committee members who feel that that is insufficient and would like us to try to get the information more than 48 hours in advance? And so let's just do this kind of by a show of hands. I can't guarantee that we're going to be able to improve on the 48 hours, but we certainly will endeavor to try. So not using the raise hand function, but just using like a real human hand. Let's start first with, for whom does the 48-hour advance provision of information, for whom does that work? If that works for you, raise your hand. Okay, so there's 1, 2, 3, 4, 5 of us. Okay, and who would like information more than 48 hours in advance? 1, 2, 3, 1, 2, 3, 4, 5, 6. Okay, so I will, Representative Harnett and I will take that information and we will see what we can do about it. Representative Harnett, did you want to be recognized?
I did. Thank you, Madam Chair. And I don't know if this would be helpful, but I don't think it's necessarily an either or. I'm thinking if we are scheduling hearings on a Tuesday, I would be comfortable having things by the Friday before, so at least I have a weekend. And 48 hours, I would like that. That would be an acceptable compromise to me, to have something by Friday if we're having these hearings on a Tuesday. I don't know if that's would.
Let's do a show of hands on that one. And again, I don't think that we can answer this question today because we need to go back to the people who are providing the information. And so we are trying to get a sense of the direction the committee would like to go. And then there are some steps we need to take before we can resolve this concern. So if you are comfortable with getting the information for the February 9 confirmation hearings on the preceding Friday, which is February 5th, could you please raise your hand? Okay, it seems like there are, I'm trying to do the math. So I would say that there are 11 of us for whom that is okay, and 3 not. So we will, could those who would like more than that notice just help us understand how much notice would feel comfortable to you? And just go through and give us the days so that I can make some notes. Representative Libby, go ahead.
To my mind, Friday is no different than Monday because it gives us a weekend, but it doesn't give us time when offices are open and you can contact other folks. So I even Thursday would be better in my view because that gives us a work day rather than Friday equaling the same as Monday, really, in practical purposes.
Okay. And Representative Hagan, were you another?
Yeah, I apologize. Thank you. I got a phone call right when you were when Representative Harnett, Chairman Harnett, was talking. So I think I misunderstood the last question where we raised our hand. I apologize. Could you restate? Then I'll either raise it or not.
Yeah, well, just let us know if you received the information the Friday before the nomination hearing. Would that be acceptable to you, or would you want the information earlier than that?
For me, I would like a week. I have a full-time job also, and plus the bills are starting to really come in, and it would just be great if I can. I love to feel prepared, and that would give me the time to study, prepare, and feel good about the rock stars that we're about to see. And I agree with Representative Moriarty. What I've seen in the past is fantastic, but if I had way more time, I could feel really confident about how I vote, and that would be what I would want. A week would be great.
Thank you. And Representative Evangelos?
Well, in the event that we're able to succeed in getting our paper files, I'm not sure what Good Friday's going to do. None of us are up here. And I mean, I'll drive up and get my files on Friday if I have to, but they won't even pay us our expenses for driving up here if we're not in a committee meeting. So Thursday would be better, a day that Judiciary is in session. If we could get them the Thursday before, then I'm already in Augusta. I know Tom's here. I know Representative Libby's here. Some of us are here, some of us aren't. But the point is, what good is Friday if we're going to be provided paper files? You don't have any way of coming up and getting them. We have to be able to pick up these files while we're in town. So, I mean, Thursday would seem to make more sense. It's a committee day. Soupy could say, your files are at such and such a location, and you know, I could pick them up Thursday. Otherwise, I gotta drive all the way up to Augusta. It's some distance and expense to myself just to pick up some files that the revisor's office won't reimburse us for. So Friday doesn't make sense.
Okay, duly noted. Representative Moriarty, is your hand raise a new hand raise or a former hand raise?
Must be the former hand.
Thank you. Is there anybody else who wants to specify a particular, and I don't want to get into like a long explanation, because I feel like we've talked a lot about what the issues are that I think we all share, but Representative Babbage, what day would work for you?
Well, I don't know if my hand was raised on like it is right now on the, I'll lower it right now because I just put it back up there to be recognized. But I was one of those who thought Friday before was an improvement, but not what I'm looking for. I'm looking for respect for the committee and within a time limit. And you know, obviously I said I'd like 14 days, but 7 days, if it were honored and if they didn't meet the 7-day requirement, that would be an automatic postponement of the hearing. Then that would be respect for the committee. And my point is that the committee if we're getting 5 in the same day, it should take us a day or two to really internalize that information. And then we should have the time to follow up if we have a question. That's my point. That's all. So yeah, I would prefer a 7-day requirement than what we currently have. So thank you.
Yeah, and I just, you know, my concern is that the consequence of delaying the hearings is that this backlog of cases that are waiting for jury trial and other court action, we're going to start to impact the public if we are not able to, for example, approve renominations in a timely fashion. So I'm just saying I get what you're saying about respect of the committee, Representative Babbage, but there's also our duty to the public that we need to take into account as well.
I hear that, and I agree totally. But and I'm not, like I say, this isn't about February 9th to me. This is about the committee's participation in the nomination process. This is an ongoing thing. And I think it should be institutionalized that the committee get information that's in advance so that if it's not adequate, we have the opportunity to follow up in a reasonable time.
Yep. Okay. Thank you. Duly noted. And I just want to move on to anybody who hasn't weighed in, who has something new that they want to contribute to the conversation. Representative Moriarty and then Representative Reckitt.
That's a new hand on the screen, by the way. Sort of a procedural and ethical question for Peggy and Sam, and that is whether, as members of the committee, we should go out individually and contact people and sources and track down information. And if we do so, how do we report back? And the position I'm coming from is fresh off 6 years of my planning board, and we were under strict legal guidance, never to obtain information from an applicant or someone interested in a zoning issue individually, that all information had to be heard by the board at the same time, at the same setting, and so forth. I don't know, Peggy or Sam, whether you have any thoughts on that in terms of past committee procedure. But I don't know how we can go out as 12 or 13 individuals and do our own sleuthing and how we report back.
Yeah, I think you're muted. Peggy, I think you're
Peggy,
muted.
you're muted.
Sorry. As much as we'd like to help you, I don't think that this is a role that we can take on and give you advice in this situation. Sorry.
I will track down the answer to that question, Representative Moriarty. That is a good question. Thank you. Let's see, Representative Rackett.
I just wanted to say that I was convinced by Representative Libby's argument that Thursday was better than Friday. I don't need a whole week, but to have one that has one day when you could reach people in the quote unquote office might be useful. So I've moved my vote from Friday to Thursday, but and I appreciate the information that Representative Libby transmitted in her discussion. So that's where I am now.
Thank you. Does anybody else want to weigh in on this issue? Representative Poirier, and then I think we'll summarize where we go from here. Go ahead.
Thank you, Madam Chair. My concern, and I definitely appreciate the time constraints and the backlog and that sort of thing, but especially for us newly elected members, we have not seen this process go through or seen these applicants before, these nominees. And I would agree with Representative Libby that even that Thursday would probably be better for us, just because we may need to connect with other people if we have questions, and a weekend isn't generally a time to do that. So I would also change to a preference of Thursday if we can't get it even sooner than that.
Thank you. Yeah, and I agree that the Thursday would certainly be much better, because we all want to do our best for our committee and for the people of Maine. So let Tom and I work on this. Tom, did you want to contribute?
I hope it's a contribution. Thank you, Madam Chair. I think we, and you and I need to talk, but I think we really need to get an answer to Representative Moriarty's question about I'm not sure what people are thinking of doing with this time. I was thinking of reviewing material, not going and doing necessarily personal interviews with folks. I think we need to answer that question. You and I need to come to find out what limits there are in the way that we proceed.
Yeah, I agree 100% that we that question has been raised by several committee members, and we should give everybody an answer. And we will give you an answer by Tuesday. On the issue of when we will get the material, we will also try our best to get you an answer on Tuesday to that. There is a third issue of in what format will the material come? Can it be printed versus will it be electronic? And that, again, we just can't answer that question now. We're just not authorized to make that decision. But we will also try to get you an answer to that on Tuesday. We will have hearings on a couple of bills on Tuesday, actually, in our committee. And I know that some committee members have very much wanted printed copies, and that it is difficult to do this without a printed copy. And that has not been resolved by the leadership who are making those decisions. If you need a printed copy and you don't have the ability to print out your own copy, please independently send me an email with your home mailing address, and I will print copies and put them in the mail to you tomorrow, since it's almost 5 o'clock. So please just send me an email if you would like copies of the bills that we are going to be considering on Tuesday, and I'll pop them in the mail to you. We actually have not voted on our committee rules, and I'm a little concerned that we don't have Senator Keim with us. And so with everybody's agreement, I would like to postpone that until Tuesday when Senator Keim is part of our conversation. Is that okay with everybody? Representative Evangelos.
Yes, that's a good idea in respect to Senator Keim, but if we're going to be hearing testimony on bills and stuff, we should do the rules first.
Okay, that's a great idea.
I'm reading the rules in here, and there are definite rules about how we conduct ourselves in the public hearing. So I think we should address the rules first, so none of us end up doing the wrong thing unintentionally. That's all.
That's a good suggestion. Thank you. Representative Harnett.
Thank you, Madam Chair. I just want to, and I don't want to belabor it or keep us here much longer, but I do want the opportunity to talk about what happened in front of AFA today when I went over to discuss the supplemental budget. But I don't need to do that today. What I would ask, I have a request for committee members to just to review an email that Peggy sent us all on January 19th, which had the supplemental budget pages that applied to the entities over which we have jurisdiction, because it'll make a lot more sense when I explain what happened if you're familiar with those. And I think we'll have some time on Tuesday. I think we only have 3 bills that we're moving forward.
Yeah, and we also have a work session on Thursday, the 4th at 1 p.m. That is the only item that we have on our agenda for that day.
My discussion could wait until then if it's not that pressing.
Okay.
But
I like your suggestion that we read the email in advance. That's great. All right, folks. Do we have, is there any other business that is pressing before we adjourn? Great. I'm not seeing anything. So we will all reconvene on Tuesday at 1 p.m. And then we're also meeting Thursday at 1. And again, please send me an email this afternoon if you want me to print and mail the bills to you. Thank you, everyone, for all your great work today.
Thank you, Madam Chair. Thanks, everyone.
Thank you so much.
Appreciate it.
Thank you all.